And we are live. Let's see if anybody joins in for a bit. Hello, everybody. Hope everybody's having a nice Saturday night. Let's see here. Yeah, so just gonna react to a sovereign citizen video sent in by one of my viewers. I had a chance to watch it earlier. It is interesting. It's only a half hour long, so hopefully we can chew through most of it pretty quickly. I'm gonna give a couple minutes to see if anybody does show up. Hope everybody's having a nice night tonight. Hey, Sean, how you doing? KDB, yeah, just right behind him. Aw, so close, so close. uh, it's all right. It all works out. Hey, Parallax. Hey, if you can't be here for long, that's fine. Uh, you guys know. I told Critter and the rest of you guys, Gabby and Matt, if I kind of get the chance to do this and there's a bug up my butt about it, why not? And there's a bit of a power vacuum in the Griff stream, so why not take advantage of it? Josh, hey Critter, hey Eric. Hope you guys are doing well. So, oh wow, 18 already. Ian, how you doing? Oh, this will be a good one. You guys will like this one. Uh, that's a personal question. That's between me and my doctor. All right, guys, I was gonna give another minute or two before we start. I was typing so fast. Hey, you'll get it the next time. Next time, always available. So who sent me this? I just want to give him credit. All right, we'll give another minute. Just hang tight. How's everybody doing tonight? Pretty good, I hope. Oh, hi, Patricia. How are you doing? Thanks for stopping by. Thank you also for being a member. Glad you like that fresh content I left for the members out there. And if you want to see that fresh content, you join and be a member. No, we don't. I need to work on a couple of those. This guy's he doesn't hit most of the sovereign citizen lingo. He just goes into court and kind of throws a temper tantrum. So the sovereign citizen bingo really wouldn't apply to like the very end of the video. Daniel, shout out from Van Wert. Yeah, hope it's nice out there tonight because over by Cleveland, very nice night tonight. Very nice night here. Do I have locals? I kind of started a locals. I think I'm waiting to get approved for it, but I'm gonna try to start that up now. Enough of you guys have asked for it. I'll probably start it. Mystery Maven, how you doing? Oh, you gotta hold me in Discord. All right, guys. Well, I think that's enough. We'll get started. It's a couple minutes. So this was sent to me by Mr. Big. He emailed it to me, and if you guys find anything cool or funny out there on YouTube, especially newer stuff, send it to me at my email address. Be happy to take a look at it. If it's really good stuff, I'll bring it to you guys in a video. And he brought me some stuff from a guy named Direct D. I don't know if that D means direct dipshit or direct dumbass, but maybe direct dolt. But we'll see. So we're gonna fire this up here. He sounds like he's got some court trouble, and it's not 100% clear. He's got some sort of case. Sounds like he had an issue being a sovereign citizen or First Amendment auditor, and ended up getting arrested. I haven't figured that out yet. Which video going back in time in his YouTube shows that, or if it does show it. So if I find that, we'll probably review that another night. But I do think this is a fun one to watch. No, I don't. No, I don't. I'm a very impressionable young man, though. So, all right, guys. Well, we're gonna get started. He's got some sort of goofy introduction. I'm not gonna let that run. I'm just gonna skip ahead to when it actually starts playing. So here we go. Make sure the sound's up. All right, sound is up.
All right, so attorney number 4, this is the rough matter. Apologize for the delay. This is CR 2021-1173-15-001, and if the state can announce.
Good morning, Your Honor. Jane Schneider.
Sorry, guys, that was set on twice play speed. The judge just announced the case, so it has not started.
Schneider for the state.
Mr. DeBrigida, I think you're still on mute because I can't hear you.
There you go. My apologies. Ron DeBrigida for Mr. Ruff, who I see is seated there at council table.
Yes, Your Honor, he does not speak for me. I'm here. I have a motion.
Mr. Ruff,
He does not speak for me.
stop. So here's what this is not. This is not Judge Judy.
Okay, now I like this. He's like, Judge Judy? Like, what's that? Like, you don't just get to speak in court. You don't get to interrupt. I love this idea of like, who's Judge Judy? I've never heard of her. Oh, come on, bro. While you're sitting around eating Cheetos every day, you probably have watched Judge Judy. I just love this nonsense of, it's the judge is trying to say this is not a place of nonsense. We have rules to follow.
I'll let you speak when I tell you to.
Yes, just like normally in life, you don't just get to interrupt and say whatever the hell you want. Especially in court. If you try to interrupt the judge, you can have a bad day. Myself, I've accidentally done that, and you can tell there's times where I've had people on streams or I've been on other streams. I have an issue kind of jumping the gun sometimes. And depending on the day your judge or magistrate's had, they can be they can have a very short fuse. So, they say, do not interrupt me again. They get mad about it. So, yes, you don't get to interrupt people. That's how this works in a normal situation. Oh, Stabby, how you doing? Haven't seen you around a little bit. Late muted and Discord modded. Judge Lisa Ann. It's not that Lisa Ann. Guys, I'm not going to make fun of the speak with I'm told. Hey, I mistype crap all the time. If you guys ever see what I tweet, I put in I misspell words or, don't get Google Talk to catch correctly what I'm saying all the time. So I'm not going to jump on them for that. We all screw up. I mean, I'll type a brief and I'll misspell things. So it happens.
Somebody's speaking for me. They do not speak for me.
Stop speaking, because what I can do is not have this hearing. So you're going to follow my rules and directions, or we won't do this hearing.
Not really due process violation because you're not following the rules. If you won't follow the rules, the court's not going to have the hearing.
And your matter will get delayed.
I'm
So
asking for a
stop
continuance.
talking until I tell you to speak and answer the things that I direct you to answer, Mr. Ruff.
No, because the judge knows it's on the record. So she knows that people will know you're speaking to him like this. It's being recorded visually and audio. So if there's ever an appeal, the appeals court's going to know she said this. To act like she has no idea what's going on, I think is a bit nonsensical. Hold on 1 second. You got a text here I need to see. Come on. All right, yeah, no, we're all good.
So, in order for us to go forward, the first thing that you need to do is indicate your name and your date of birth. Mr. Ruff.
My name is Christopher Ruff.
Thank you. All right, so this is the time set for the final trial management conference. I will note that we were last here on March 8th of 2022, and at that time, the court did release Mr. Lockhart
So let's pause a second and go into who David Lockhart is and why the court excused him. The court excused him because I asked David to do things to help prepare for my defense, and he did absolutely nothing. And then when I told him that if he didn't help me, I was going to file a bar complaint, he excused himself from the case. Feel free to pause this and read this email. This is not an email that you should get from your lawyer on a felony case where they're trying to put you in prison. This guy doesn't give two hoots whether or not I'm guilty or not. He's just going to collect a paycheck trying to defend me in a courtroom where everybody knows him. If you go back deeper into his history and you read his reviews, he's been in a lot of trouble, and a lot of people don't feel that he's a very good lawyer. Check him out. And from one bad lawyer.
Okay. So this is the temper tantrum really kicking you off. I don't know why he's got this picture of this lady here. I guess it's supposed to be the judge, but I don't know why the judge is up here when you're bitching about your previous attorney. I mean, you got to stick with the narrative here, buddy. Like, you got to focus the topics. Supposedly this is from his attorney. Now, I don't know if this is true or not, and who knows. Now, if this is from his attorney, why don't we see like the email headings, any of the stuff that would show some authenticity here? I don't know. Oh, anything over 700 FPS, you have to register with the state to purchase. Oh, geez, that sucks. You live in New Jersey? I guess that's what kind of sounds like there. Anyway, we're gonna get to this now. He's complaining that he says, his attorney's saying, well, I recognize that you're the client. I am still the attorney. And I decide, not you, the strategy for motions to file, of course, with your input. And that's true. The attorney is in charge of tactical decisions. The attorney is in charge of how a trial is going to be conducted. What strategy is employed, what evidence is used, how you're going to use it, what witnesses you call, what you're going to ask them. The major decisions of the trial, like, are you going to have a trial, a bench trial, a jury trial? Are you going to enter a plea? All those things are your ability. Those are under your control. The way I try to describe it to people is, think about it like if we're going to go eat dinner and we're sitting in the parking lot of somewhere and you tell me where you want to go to eat. Let's say you want to go to Red Lobster. Let's say you're fancy like that. I may drive you halfway across town, but I promise to take you to Red Lobster. You will get to go eat at Red Lobster and eat all the cheddar biscuits you want, but I get to choose how that happens. So this is not, there's nothing wrong with that. Now this part here, it says, now my opinion of what you did, regardless of whether it was illegal or legal, was unwarranted and completely designed to antagonize the police. You were not the subject of the investigation, nor did the police initially engage you. Candidly, it was none of your business, but you chose to interrupt and disrupt what they were doing, regardless of whether you agreed or disagreed with them. This is him giving legal advice. He's telling him, here's what I think of your case, and here's what I think you did. I mean, would you want this guy to lie to you and tell you, oh, no, it's okay, I agree with you fully? No. Part of my job as an attorney is to say, look, what you did was stupid. What you did is going to get you convicted. Or, hey, yes, here's some bad things, but here's some really good things in your favor. We can use some of this good stuff and we can maximize it. If you want to go to trial, I think it's a good idea. Or on the other hand, look, you completely screwed up. The facts are not in your favor here. We need to talk about probably the unpleasant option of maybe trying to see if we can reach a plea deal with the state. It's just very hilarious. He doesn't, it's just turning out this is just conversation he doesn't like to have. He's being told no, and he doesn't like that. And the attorney starts talking about the cops can be abusive. And he does point out that, what transpired between you and the police never should have happened, nor should it have resulted in charges filing against you. But he is saying, like, your actions are the reason you're now facing prosecution. And there's nothing wrong with telling somebody, look, this is the consequence of your actions. Maybe if you weren't such an asshole, you wouldn't be here. Now, would I ever say it like that? No, but this attorney can phrase it however he wants. If this is even what he said, we have no proof of that because we just have a snippet without any attachments. He does does call him out, though. Apparently, appears you have a practice of being confrontational with officers. And it's apparently, he calls this guy as a chip on his shoulder and an axe to grind. There's nothing wrong with that necessarily. I would never do that to a client. I would just say it appears we obviously disagree. But none of this is unethical or unprofessional. It's just I wouldn't necessarily do it. Hey, Cool Frog, how you doing? Oh, yes, the good biscuits. Yeah, they're good. Can make them at home.
To another, the court is trying to stick me with this guy named Ron DeBrigida after I have clearly submitted the proper paperwork to defend myself. They are adamantly trying to not allow me to do this, and I'm going to show you. To another, they stick me with a guy who doesn't help people and then transfer me to another guy who admittedly doesn't help people and doesn't communicate with his clients. Feel free to pause all of this and read it very thoroughly, because this is from the Supreme Court of Arizona when they admonished this man for not doing his job correctly. I mean, this court case happened almost a month ago. This guy has been in trouble for not communicating with his clients, and I haven't even heard from him except for the one time that I called him to make sure that a court order was sated. Something to keep in mind when you watch.
So yes, it appears that this is one part I think he does have the right to be concerned. This guy has previously been admonished for not engaging in contact with his clients. So, and that he just did not engage in contacting his clients. But okay, that does happen. Some attorneys are not the best at that. But notice that they placed him on probation for 2 years, and they admonished him, which is kind of like a formal reprimand. That is not a suspension of license. It's not a severe grievance. It's not a severe infraction, but still, it's not good. You don't want an attorney who does this. But I would also point out, it looks like it was about 4 years ago. So, sometimes people slip up and they have rough patches in their job and they get back on track. So without any more, I would assume this guy's back on track. I have no reason to believe he's not. Especially not from this guy. I'm not going to take his word for it.
Watch this next part. I filed the proper paperwork. I submitted it to the clerk court and to the court, and I had copies when I was in court. But yet this judge is still going to deny my motions like I don't even know what I'm talking about and I'm not doing it right. I followed the rules to a T, and she's still violating them.
Mr. Ruff, I'm going to
We'll get to that. He's not following him to a T. Surprise.
get to you in just a moment. But first, Mr. DeBrigida, have you been able to obtain discovery either from the state or from Mr. Lockhart?
Judge, I was speaking with Mr. Lockhart at the end of last week and again yesterday. I'm actually on my way downtown shortly. I would have been there actually in your courtroom, but for a nail in my tire. But I'm coming down for trial with.
Okay, this part for the attorney, like, bro, get a plug and patch kit. I mean, I carry one in my car. Nail can't hold you up. Come on now. You can fix that on your own. It's not that hard.
Judge Fish. But I'm also going to drop off a thumb drive to Mr. Lockhart's office so he can give me the disclosure materials.
Okay, so he may already have the discovery. If I'm an attorney and I jump into a case and the client already has discovery or another attorney has discovery, I'm still going to go to the prosecutor. Why? Because that way I know I'm getting everything. If you're the client and you may have discovery, how do I know you haven't lost anything? How do I know you haven't altered it to say, look, see, this is all in my favor? I can't verify those documents you have because they're not your documents. You didn't generate them. So if I go to the prosecutor and get them all, it's a brand new batch. That way I know it's good. I know it's legit. I know there's no question about them. So I don't understand why he's worried about having discovery. But, once again, it's a home gamer. I don't think he knows what he's doing.
Okay. Mr. Ruff, you wanted to be heard about Mr. DeBrigida being counsel of record. Go ahead.
Mr. Bridget does not represent me. I do not consent to the public defender's office taking anything on my behalf. I have a motion right here to waive my rights and represent myself, as well as a motion to continue for 6 weeks so I can prepare myself for trial, submit subpoenas, interview witnesses, and proceed with due process in my case, because it's obvious that my public defenders over the last year have not done this. So I am going to be representing myself. I have a motion. I had it submitted to a clerk of the court already. I have a copy of that.
Yes, so this is a motion. It looks like it's been file stamped from April 11th. But if you notice, it sounds like when you watch the captions, this all happened in May. So this is like a 3-week-old motion. Yes, a nail in the tire. Yes. Okay. It's like getting thrown under the bus or over the bus. Or can I throw the bus under the guy? There are people who can do it properly. At least they get the smart parts down. So it's not always bad, but we'll keep going.
When did you file it with the clerk of the court?
April 1st, or April 11th, 2023.
Heather, do you see it?
Jay Taylor, deputy clerk, signed for it. This is pursuant to courtroom rule 6.1C.
Okay.
I'm sorry,
Mr.
Your Honor,
Ruff,
what
you
was
were
that?
required-
What was
Sorry,
that date, Your Honor?
What was the date? April 11th was the date that Mr. Ruff indicated. Mr. Ruff, you were required to deliver a copy to this division as well, pursuant to rule.
I have it right here.
Okay, you were supposed to do that when you filed it, sir.
Okay. Now, we're going to go back real quick because he does try to say, 646, okay, that someone signed for it. That is not somebody signing for the document. That is literally a timestamp, and it just shows that the clerk of the Superior Court is Jay Taylor. That's nobody actually signing for it. That's probably an assistant clerk. It's just somebody who literally shoved it in the machine and got stamped. Yeah, Ted Bundy represented himself. Carlos, how you doing? Hope you're going well. Hope you're having a nice night. But if you hear the judge, there is an issue. When you file a motion, when you serve any paperwork, courts almost always want a courtesy copy. And that's merely you take a copy if you file a motion, and then you take a copy to the court. Just so you guys know, if you're ever representing yourself, this is a kind of a free tip. If you make sure they have the courtesy copy and they get it right away, they might be able to rule on your motion quickly. Because if you have if you have a motion and an order and you give it to the court, well, they don't have to wait for the clerk of courts to process everything and they get something to them. Or if they have to go check a Dropbox somewhere, if you take it to the court, you might be able to get it done right away. So that's some free information there.
Filed it, sir. Having said that, Mr. DeBrigida, have you received a copy?
Now, you are about to see and hear a Superior Court judge in Arizona named Lisa Ann Vandenberg work with the prosecutor and this pretend lawyer they're trying to stick me with to claim that I didn't file this paperwork that you're looking at right now. So you notice the sticker up at the top right-hand corner. That sticker only comes from the clerk of the court when you go and you file this paperwork. And when you first go and file this paperwork, they ask you how many copies you need. And I asked them, why do I need copies? And they said, well, you need to go upstairs and you need to put copies in the judge's box and the prosecutor's box. Well, I did that. These papers were hand-delivered into their motions box. There is no way they didn't get this. What they're trying to say is that it wasn't filed with the electronics.
You bring your own copies. You don't ask them to print those out for you. You bring all the copies you want stamped. This nonsense already doesn't make any sense. Most clerks won't print these out for you. Oh, raid from Uncivil Law. Thanks for stopping by, guys. Appreciate it. It's a lot. Holy cow, a lot of you.
system yet and that they don't have it in front of them, which is not an excuse to pretend I didn't file a motion, especially when I brought copies into the courtroom. You are allowed to walk a motion into court and deliver it in court, but yet the judge is going to pretend like that's not even a thing and she's not going to hear anything I have to say.
You can walk a motion into court, but to drop a motion on the court like the day of a hearing doesn't usually go well because the court needs time to look at it and respond. So to act like this is improper, once again, bro, you're not doing this right.
No, and I'm looking at the docket now. I don't see it was filed.
And did the state receive a copy?
No, Your Honor, I have not received a copy.
Okay, well, so there's the first, I will just tell you, Mr. Ruff, in order to consider whether or not to release Mr. DeBrigida, there are certain things that I need to consider.
Actually, Vandenberg, there's nothing you need to consider. The only thing you need to consider is if I waived my rights knowingly and intelligently, and if I have the capability to follow along and understand what's happening. That's pretty much it. You guys should Google this case law I put up on the screen.
Okay, well, real quick. Oh, hey, Kurt. Yeah, thank you very much. I appreciate it. Hope you have a nice night, relaxing, and get ready for the bar. Good luck. Why the mask? Some courts still require you to wear a mask if you show up. It is entirely dependent on the judge. Some courtrooms require them, some don't, and it might be courtroom from courtroom to courtroom in the same courthouse, or some courthouses will just now require them still. It's entirely whatever you want. Okay, so for all the uncivil guys, this is a guy named Direct D. He is a sovereign citizen out of Arizona, and he's trying to represent himself in a court hearing. He got rid of his previous attorney, and now he's trying to get rid of the public defender, and now he's starting to have trouble with it. I think it's interesting, though, he cites this case law here, this case Ferretta v. California, which, U.S. Supreme Court 1975. That's not the way you cite cases. So I don't know why he thinks that's the way you cite them. It's not how you do that at all. I can't Google that and find those things. But yes, the judge must allow, you have the right to represent yourself if the judge determines you're competent to understand the trial and participate in the proceedings. And then notice the second part. They have the power to decide that a person is mentally competent to stand trial, yet not competent enough to represent themselves. And that's true too. Because you have to follow the rules, you have to have some level of understanding. I'm a boat captain. Yeah. Yes. In Russia, the bar exam, dude, that sounds very not fun. So we're gonna keep moving.
So what's starting to happen in my trial is they really don't want me to represent myself, and this judge and the prosecutor are doing everything in their power.
Okay, now he's worried about in federal courts. Okay, we're not in a federal court, we're in a state court. So none of this is controlling. It might be persuasive, but he's using Chuck E. Cheese coins at a casino. It doesn't work.
Power to stop me. I've already appealed it, and I'm about to submit a second special action appeal today as I'm making this video. So keep watching it, because as you're watching this, I'm filing more appeals and trying to get this into
I'm
a higher
sure those
court,
appeals are going to
because they
go
are
well.
totally violating my rights. The right to represent yourself has been established for so long, it's not even funny. It's in Arizona
But this is funny.
Constitution. It's in the United States Constitution. It's all over the place except for in this woman's head.
And so whether or not I make a finding that you can represent yourself, or make a finding that Mr. DeBrigida should not be your attorney of record, I will just tell you there are certain things that I need to consider.
This is correct. I don't know what this is from. But oh, Somebody wants. Oh, somebody's here. Hi, Ruckle. How you doing?
Oh, doing well. You got to give us more than 0 minutes of notice when you want people to join in, though.
Yeah, well, I'd been going for a little while. We haven't gotten too far yet.
Fair enough.
Yeah.
Uh.
Yeah. See, well, actually, I should say, no, I've been going for 30 minutes. You're just late. So this is a sovereign citizen out of Arizona. He wants to represent himself. He fired his first lawyer, and he doesn't want the public defender. And he just brought up that he filed a motion about 3 weeks prior, and nobody ever got a copy of it. So,
Oh, well, that's always says that you've done all the things that are important to do when you file a
yes,
motion.
yes. Oh, and this is now when it gets good. This is now when it gets good. Also, yeah, feel free to jump in and argue, point out anything if you want. I'll stop it.
Sounds good.
All right, here we go. Oh, everybody. Oh, Zach wants you to show your sword.
Oh, it's in the other room at the moment, so I'd have to get
up. All right. All right, here we go. Sorry, he has these screens of walls of text.
Oh, lovely.
Yeah. Yes, and he doesn't cite well, so it's hard to follow along where he's citing.
Well, and is he citing to actual law, or is he citing to the usual?
He might be, but I'm not going to look it up because it's not properly cited. I'll give him the benefit of the doubt that he's citing real things.
So in order to represent yourself, I need to be satisfied that you would be able to comply with the rules and hold yourself to a similar standard as a defense attorney.
What kind of crap is that? I have to satisfy the judge to be allowed to represent myself and hold myself to a similar standard as a lawyer. Nowhere in the court rules or case law does it say anything about this. This woman is totally making up her own standards for what I can do and what I can't do if I want to represent myself. That's
not true at all. Yeah,
he's got his own editorialization. Were we supposed to be seeing video there?
Yeah, that back part was the Zoom hearing.
Okay.
This was the Zoom hearing itself here. Oh, can you not see this right here? Oh,
nope.
Oh shit! I'm sorry. Oh fuck! I gotta go back. Sorry, I forgot.
And I am not attractive enough to fill in for that.
All right, here. This is him in the red shirt. So we'll just start it back over.
And hold yourself to a similar standard as a defense attorney.
What kind of crap is that? I have to satisfy the judge to be allowed to. In the court rules or case law, does it say anything about this? This woman is self.
Judge gets to run her show, and also you can't just be throwing poop at things.
Yeah, I did not share it, Boomer. I know. Jim, I actually have looked into this a little bit. I need to do a lot more digging. But yes, I've started to read. Holy cow, it's really bad. I don't know if you can read that, Runkle, but New York's trying to extradite a Tennessee gun dealer for stuff.
For stuff, okay.
Yeah, for guns making their way up there, yeah.
That's going to be exciting.
Yeah, well, yeah. But guys, just so you know, when this works, when you represent yourself in court, this is actually done at the appellate level. I'm not sure in Canada if they mention this, but they clearly state you are held to the same standards as an attorney. So if you represent yourself, lose a case, and go on the appeal and cry and say it was unfair, or I didn't know, the appeals court say, sorry, you have to follow the rules just like a regular attorney does. So for him to say there's no case law, there are millions of cases where this happens.
I mean, judges will often cut self-represented accused and self-represented individuals all sorts of favors that they might not cut for a lawyer.
Sure.
Oh, you didn't file this. Well, you were supposed to file this. We're going to allow you to do it with no notice. Just hand out a copy to everybody. That kind of thing happens all the time. But, I mean, technically, they should have to follow exactly the same standards. And, yeah. And also in terms of things like decorum in court, you've got to follow that.
Well, in my experience, some of the little rules they'll bend in your favor as a pro se litigant, but the serious things, like if you're in court and there's objections or the rules of evidence, there is no leeway. You're held to that exact standard. So that's where I don't think this guy understands that if you go and try to cry about it and say it's not fair, the court's going to laugh at you.
Well, I
Because-
mean, he's a sovereign citizen. I've already seen
well-
him do the bar capital letters thing.
Yes.
Um,
Yes.
I can see that he does not understand much.
Mhm.
That's always
Yeah.
fun when I get people. Sometimes I'll get people in my comment section going, "Oh, well, this guy's a member of the BAR," and I'm like, "Yeah, it means I win sometimes." As
Yes.
opposed to you. Yeah, these sovereign citizens, when they walk into court and finally get a chance to try out all of their mumbo jumbo, and they're always so shocked when it fails.
Yes. Yes. Very much so. But yeah, guys, there is actually case law where you are held to the standards. Oh, yes. Yeah. What was I doing here? Okay, we're gonna keep going from here. I love his indignation here.
Yeah.
For Brianna 25 super chat $5 or $4.99. Thank you very much. I appreciate that. Soft sits are always one word away from finding the perfect precedent to win their argument. Yep. They're missing that one magic word. They think that'll help them.
Is that word law school?
Yes.
Yeah.
Oh yeah. Yeah. They're just, they're like a gambling addict. They're like, the next one's gonna work. I got a feeling.
Well, I mean, some of them go in, they lose, they take their lumps, and they walk away, and they've learned something.
Mhm.
Some of them just keep coming back because every loss they have is just a further reinforcement of like, oh, well, this just shows the system is, against me. But next
Yes.
time I'll get them. It's like, it's just so bizarre when you're imagining this giant conspiracy against you that goes away the instant you ask it nicely to.
Mhm.
Like,
Yeah.
it's so bizarre.
Yes.
Like, even the premise just doesn't make any sense.
Yeah, and Just Aaron, you're right. Most of these are just decorum calls, and the judge does steer the courtroom. But I would say that big thing about making sure you file motions, that's starting to get more into not just decorum, but that's actually handling the practice of law. So you have to do that part right.
All right, let's
Yeah,
hear
let's
what
keep
else
rolling.
this guy's got to say.
It gets going.
That's not how this works.
It is, though.
And the fact that you weren't
Yes.
able to comply with the simple rule of filing and delivering a copy of your motion timely to the attorneys and to the court is something I need to consider.
See, I'm not quite sure how she understands or thinks that she's going to get away with this, because I literally have copies of the copies that I gave to the court when I submitted my paperwork. There's boxes that you put this stuff in. It's not my job to hand deliver it to them. And on top of it, even if I wanted to.
Well, if your court has delivery boxes, that will suffice, but I'm doubting he did it right or put them in the right boxes or did any of that correctly.
I mean,
So-
where I am, you'd file that, you'd get a filed copy,
Mhm.
and then you'd serve it on the other side and get an affidavit of service. So,
Yes.
Although if you're working with a lawyer and that lawyer's not a jerk, like a lawyer on the other side, almost always you can deliver it to them and they'll just say, "Yes, I've got a copy."
Mhm.
I've never had a problem with law firms accepting service.
Yeah.
But if you're talking about like an individual, then yeah, you get an affidavit of service because
Mhm. Oh yeah, if it's an individual, it's different. But yeah, even here, I've emailed motion. You can email motions in my area, so and that helps. I mean, especially if it's the prosecutor, like they've got emails, like you can prove that it went. You can prove they opened it.
Yeah.
So yeah, I just don't think this guy filed it right. I mean, he may have thought he did it correctly. I don't think everybody's lying and attempting to screw him. That's where you lose me.
Yeah, no, it's just that, I mean, this is basically like feeling really upset because you're trying to fix your car with Tinker Toys.
Yes.
And you're thinking it's a conspiracy that now your car won't run because, you've
Yes.
you've got the part from the big wheels in there. Why isn't it
Yeah.
working?
Yeah, the pedals aren't helping. Okay, and I think this might be right, Sean. Yeah, it sounds like he learned the boxes after the fact. That could very well be the case.
Yeah.
And once again, part of determining your competency to represent yourself is, can you understand the rules and follow them? And so far, we're 0 for 1.
I could have came into court and hand delivered it to him. I had copies. I told the judge I had copies, and she refused to take them from me. And then she's sitting here telling me that I didn't file the paperwork. Are you guys seeing what's happening here? This is a total sham. This happens in every single courtroom. The judge doesn't know what's going on. The prosecutor doesn't know what's going on. And they still work together to screw everybody, regardless of whether or not you're right or you did anything wrong. This is the system. It's a game. It's a chess match. They get taught how to play chess in law school. They don't get taught the law.
Having said that, if I had received your written motion, what would be the basis for withdrawing counsel? What's written in your motion is what I'm asking you.
Courtroom Rule 6.1c, as well as the Supreme Court case.
Okay, stop. I didn't ask you for case law.
Well, no, you didn't specifically ask me for case law, but you did say what is specifically written in your brief or in your motion to represent yourself. And right there on your screen is Rule 6.1c and case law. Why is she saying she doesn't want to hear case law? On your left side of the screen is the Arizona State Constitution. Preamble.
The reason why is she's asking you what is the general idea of your motion. She doesn't want you to read it to her. She can read it herself, but she's asking you for the summary. Like, what's the reason why you don't want him? She's not asking you for case law, and I get that. He's kind of like axiomally correct in a smarmy way that she didn't say what he wanted, but I assume it's very much the same way for you in court. The judge says, like, what's the point of the motion?
Oh yeah, and they want you to be able to explain sort of what your
Yeah. You don't need to talk about the case law. She's probably aware of it, but she wants to know, is there something special in here? And you could argue, yes, this guy's been in contact with me. I feel that's prejudiced me. I feel there's a breakdown of the attorney-client relationship. You could say all those things without citing case law. But once again, he doesn't do that.
Even just, hey, I think this guy's a jerk.
Yeah. Yes. But he's worried about the. You can tell. Why do they do the insanity scribble around like the Declaration of Rights? Why can't it just be like draw a circle? Instead, it's like going a beautiful mind on it.
I have no idea.
I mean, like, you can go into Microsoft Paint and just like do the circle drag in like a nice clean circle. And it doesn't look like a guy who's going to go stand up in a bell tower anytime soon.
But I mean, this guy gives every vibe that he's looking for the right bell tower.
No, he does.
The right bell tower on the wrong day.
Yes. I mean, that circle almost looks like it's out of The Ring. So let's listen to more of this.
Number 2, Declaration of Rights. You go into that, you click on it. It says that the supreme law of the land, authority to exercise sovereign authority against federal actions. Section 3A, the Constitution of the United States is the supreme law of the land to which all government, state and federal, is subject. That means you, Judge. Mm-hmm. So you telling me you don't want to hear case laws like saying, I don't want to follow the rules and I'm going to do whatever I want because this is my courtroom.
That's actually a very interesting self-report. I don't think he realizes that.
Yeah.
Yes, very, very revealing.
The written reasons.
The written reasons are, I don't have body cam footage from the state from everybody. I don't have the particulars motion. I don't have full discovery. I don't have anything that I'm supposed to have. And
it's interesting, at the beginning of this video, he makes a comment that this attorney, the guy down here with the gray hair, shouldn't be complaining that he didn't get discovery from the prosecutor because he already has it. But as you can see, he actually does make a good argument. Your Honor, I don't have full discovery. I haven't had time to prepare. And that's what he should have done before acting like a dickhead.
If he was able.
Yes. If he could restrain himself.
On top of that, it is my absolute right to have counsel of my choice. I do not have to have the state represent me. You are going to violate my due process by trying to force this contract upon me. I do not consent to this whatsoever. I am going to represent myself.
But have
The
you
contract.
had any communication with Mr. DeBridge?
You don't need to have any.
Let me finish my question. We are not going to talk at the same time, Mr. Ruff. That's just not going to happen. My question was, have you had any contact with Mr. DeBridge since he was identified as counsel by the Office of Public Defense Services?
I didn't identify anybody.
It's a yes or a no. Have you had any contact with Mr. DeBridge since he was identified as your attorney?
As he tried to reach out to me, so no, I haven't had any contact. I didn't even know who DeBridge was until today.
So the answer is no. Thank you. Mr. DeBridge, have you had any attempts of having contact with Mr. Rupp? I know you said your intention was to physically be here and you had an issue.
Now, keep in mind, as he answers this question, this man was admonished 2 years ago for lack of communication with his clients by the courts. He's already been in trouble for not communicating, and he still ain't doing it. I talked to him. I called him, and it took me a month to get a hold of him, and he still has not sent me anything. If he's supposed to be my attorney on record, how come I don't have anything in my email from him? I gave it to him in court.
Right, Judge. And
Now, I will say this is correct. Apparently, this attorney did get admonished like 3 or 4 years ago for not communicating properly with his clients, but it was only an admonishment. There wasn't, it's just like a reprimand. He wasn't sanctioned or anything like that. So, and that's actually a good reason why you don't want this guy representing you. That would be a valid reason to bring up.
Yep.
But instead, he's complaining about other things. And also, if he has these claims, this guy's never contacted him. He hasn't shown us, so not sure he's telling the truth.
the other thing that I was hoping to get from Mr. Lockhart was contact information for Mr. Ruff, because OPDS did not provide me with any.
Okay, so you haven't been able to try to have contact.
No, Judge.
Let me turn to the state. With regards to Mr. Ruff's request to continue the matter for 60 days, does the state take a position?
Your Honor, I don't have any objection to a continuance. I don't know. 60 days puts us in the middle of what, June? There are some, I'm not all that available in June and July, but I'm sure we could find a few days that we could make work.
Oh, please, whenever it's convenient for you to maliciously prosecute me, let's just make it work, right? Because you haven't looked at the case, and if you have...
I mean, he just asked himself for 6 weeks he asked for 6 weeks for himself. And I don't think you were here for that part. He wanted 6 weeks to prepare. So, now nobody can ask for 6 weeks. I just you're losing the plot here, man.
Yeah.
This part I thought was so hilarious, because he does at the beginning say, actually, were you here for that? When he said he wanted 6 weeks? Okay. He said he wanted 6 weeks to prepare and go interview witnesses. So now it's not acceptable anymore. Oh, Mookie, can't afford a super chat. No, don't worry about it. You being here, clicking like is awesome enough, and I appreciate that. You need a break from the insanity? Well, you can watch somebody else's insanity, I guess. Hopefully that helps.
Yeah.
All right, let's keep going.
You'd be throwing it out by now because you're maliciously prosecuting a case. But it's okay. I'm trying to get this stuff into the Supreme Court, into the appellate courts. You guys are dumb, arresting me on a sidewalk and then trying to maliciously prosecute me.
Just a moment.
I do wish to make a record regarding Mr. Ruff's request. He does not have a right to counsel of his choice.
Yeah, just about nowhere gives you the right to pick your counsel. You've got a right to have, unless you can afford to hire that counsel.
Yes, if you can afford an attorney, yes, these people are being paid big bucks to be ignorant. Yeah, so I know. You cracked the code, brother. Nobody else knows it but you. Yes, you don't get to keep getting rid of public defenders, and you don't get to choose the one you want.
Yeah.
But like you said, Runkle, if you can afford that guy, go hire that guy. Because I guarantee it, in the back of his mind, he would like to go force the most prestigious attorney in his town to come defend him.
And they're
At
going to
his
be like,
command.
nah,
Yeah.
no thanks.
I know, but I think in his world, he should be able to force that to happen. And I always think that's funny as a sovereign citizen. They're about freedom and whatnot, but they want to, have conscripted work out of people. Super chat from Walter Malone. It's the great Walter Malone for $10. Thank you, Walter. Just caught the stream. Did I miss the part where the Sov argues over jurisdiction? It always comes up. No, it has not happened. That all stuff happens at the end, but we'll get to there. We're almost there.
He has a right to counsel. And I think that needs to be addressed with him.
Well, okay, so Mr. Ruff, you do not have the floor. I'm not going to say it again. I don't repeat myself. So I can reset this matter. We can delay your case, but we aren't going to talk at the same time, and you're not going to talk unless I give you the floor. Having said that, I disagree with counsel for the state. I understand what the state is wanting the court to clarify for the record, and I'm happy to do it. I'm just one thing at a time. So I will address what the state's talking about. Give me just a moment. I'm just trying to get back to the charges in this case. Okay, so the case that's in front of me right now has one count, as far as I can tell, and that is a Class 6 felony resisting arrest accusation that is alleged to have happened on May 9th of 2021. So the reason that I wanted to look at that is, Mr. Ruff, some of the things that I have to consider with regards to whether or not it's appropriate for you to represent yourself is the complexity of the charges. Let me ask you, have you ever represented yourself in a criminal proceeding where a felony was at issue?
I mean, that's irrelevant to wanting to represent myself right now. There's no victim in this case, so there's no reason not to continue it.
Okay.
It's not complex.
There's no
I'm
corpus
going to direct
delicti.
you to answer my question.
I said no. I told you no.
You said it was irrelevant.
I said it's irrelevant, but no.
So which one is it?
How far did you get in school?
Well, I mean, it can be
Mr. Ruff?
both.
Graduated high school.
You speak and understand English.
Now, if you don't understand, let me tell you. To ask somebody if they speak and understand English as you are talking to them in English is beyond insulting.
Well, no, she's got to confirm that on the record.
Yes. And that happens all the time. If you enter a plea, the judge asks, do you understand the English language as written and spoken? That's not offensive at all. It has to be established.
Also, dude, your feelings are hurt? Oh,
Mhm.
Muffin. You're going to hate
know.
what happens next when they sentence you.
Yeah, big mad, big sad. It's offensive. It's like, is the Admiralty Court and the Road Pirates, do they hurt your feelings? I bet that fringe on the flag hurts his feelings too.
It always does. They really...
It's just a juggalo. No. Juggalos are a little bit smarter. I give them some credit.
I assume that the mask is COVID related, or is that just
well,
sometimes they've got funny hats? That's always hilarious.
No, I think because he's actually in the courtroom with the judge. This judge has a mask on, and I don't know about in Canada, but it's literally from even in the same courthouse. You can have some courtrooms where you have to wear a mask, some you don't.
Yep, same is going on here.
It's from judge to judge, so I assume this judge makes you wear a mask.
No, that makes sense.
Yeah.
I mean, he's got to do what...
Yeah. So...
At least he's able to play ball that far. Because, I mean, the judge runs the show. You can disagree with it, but you're going to end up getting hammered.
Yes. Yes. Yeah. And Nicholas is right. Yes. Considering the literacy rate in America, it's a fair question. Yes, because there are people who do graduate high school who cannot read or write, so, and can't speak very well. So it's not an insulting question, and it's something a court has to confirm in writing. Otherwise, that's an appealable issue
And
because
this
it's never
guy's
established.
not exactly doing a fantastic job of,
Yes.
So yeah.
Yeah.
And this woman does not need to be doing any of this. All the case law, it just says that I have to knowingly and willingly waive my right to counsel to represent myself.
And to determine whether you can knowingly and willingly and intelligently waive your rights is if, do you understand the words coming out of my mouth? to quote Rush Hour.
All of this right here is like a competency hearing. And she continues.
Yes, it is.
Yep. And one of the questions they will
Brilliant
ask you in one
fucking
of those
assessment.
is, do you speak and understand English?
Yes. Yes.
Continues to try and say that I am not competent to represent myself in minute entries and all kinds of stuff. Crazy.
Ma'am, I'm not going to answer any more of these questions because I've given you my motion. It's right here. I've submitted it with the clerk. This is not a competency hearing for me. I'm just asking you to hear a motion today. That's it.
He did
We're
just
not
said
doing-
it
if
is
you wanna
exactly
set
like
a
one.
competency hearing, we can
Yes,
schedule a
voiceover.
competency hearing. If that's what the court wants to do, then let's prove that I'm not competent enough to represent myself. How about that? Then I'll submit this next time and I'll do it the way you want it to.
At this point, the court does not find that Mr. Ruff has demonstrated enough information where the court could understate v. Hartford.
So right now she's listing reasons as to why I can't represent myself. And the first one was State v. Hartford. Now, if you know anything about this case, it just means that I can't unreasonably refuse counsel and then turn around and claim a due process violation by refusing the counsel. So I don't know how that is relevant to whether or not I can represent myself right now. I haven't even been found guilty to go and say that I had ineffective counsel.
Because this judge is smart and knows the minute it doesn't go right, you're going to go scream and cry about it. One. Number two, I'm sure that there's a lot more to that opinion than just 2 boxes of text. So notice he doesn't show us the rest of it. And I'm sure they count on the issue of making sure you have to competently be rejecting counsel. So once again, they don't show everything.
Now, I don't know if she was just spouting this case law off to make her seem intelligent or make it seem like she knew some stuff. But as soon as I heard this, I knew she had no clue what she was talking about. And that's why she told me she didn't want to hear case law in the beginning. Because these judges and the prosecutors, even my own lawyers that I paid thousands of dollars for, do not know case law. It's extremely sad. So sad.
Or the standard colloquy for considering a request to waive
Everybody
the right
is
to
stupid but
counsel.
me.
Now, colloquy is a court standard that bar members or lawyers are supposed to adhere to. They cannot expect or even know what the... Oh, my gosh. I am so clustered when I hear these people speak. They expect you to behave and act and know everything just like a lawyer does, and that is not how it goes. The reason she's doing this is because she would have to essentially assist me in the court procedures, and she absolutely does not want to do that. She just wants to snip, 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 and it's...
Yes, she doesn't want to because it's not fair for her to do that. She shouldn't be assisting you because then that's unfair. It's not fair to the other side. Yet once again, he's almost there. He's getting he's just like one more scoop, one more shovel full of dirt, and he would have found it. He would have found the understanding. But yes, you're expected to understand, and I do like the idea he gets clustered. I'm sure he meant flustered. But yes, the ability to not maintain that thought when you get flustered. Yeah, that's not going to make you look competent in front of a judge. Oh,
done just like every other case that comes across her desk. But guess what? I'm not going to be that easy.
And so at this point, the court will not entertain that request. I'm happy to entertain it if at some
Use your
point.
bond information.
I'm happy
For
to
your oath
entertain.
of office.
I'm happy to entertain it.
now we're getting to the oaths of office.
Yours is
I told you guys we get to the fun stuff.
well.
If or when Mr. Ruff wants to submit to the colloquy that the court needs to do in order to confirm whether or not it's appropriate to allow him to represent himself.
Now, I know everything she said sounded official. In order for him to represent himself, he has to demonstrate proper colloquy, blah, blah, blah. But she's literally making this stuff up right now. There is no case law supporting what she's talking about. There are no laws or court rules supporting what she's talking about. This woman is literally writing her own book on when and who can represent themselves based on what she thinks is appropriate.
What's that, Runkle?
I said pot kettle.
Yes. Somebody else is making shit up as they go too.
She is completely out of her mind. And this is what all the judges
Another self-report.
and prosecutors do. Literally in Arizona, I can't speak for
To be fair, I do think most prosecutors don't know what they're doing, but that's a separate matter.
Yeah, there can be some of that.
other states, but in Arizona, they have been doing this for so long, it's second nature. She probably doesn't even realize how stupid she sounds.
Again,
Having said that,
Yes.
right now, Mr. DeBridges is still your counsel.
He's not.
We will revisit.
Absolutely not.
We will revisit that at the next setting. Mr. DeBridges, at this point, I'm inclined to find extraordinary circumstance and reset the matter.
I just wanted to bring this up real quick. The Supreme Court has ruled judges have to assist a pro se person. They have to give you some leeway, but let's say you actually go to trial. The judge is not there to help you. You're on your own. When it comes to like a suppression hearing, you're on your own. In a pretrial, yeah, the judge is going to give you some leeway and maybe help you figure some stuff out. But no, at the end of the day, it's all on you. So kind of right, but not 100% right there, I would say.
At the schedule that Mr. Ruff suggested in 60 days. Do you wish to be heard on that issue?
That's fine with me, Judge.
I'm going to give dates, and then we'll talk about the issue that the state wanted to raise, and then we'll talk more about what's going to happen at that next setting. Heather?
Trial June 28th, SMC June 8th at 10:10.
Good. So I have the new final trial management conference June 8th at 10:10. New trial date June 28th at 9 a.m. with the assignment calendar. First, Mr. Ruff, do those dates work for you?
Sure, but I reserve the right to change my mind.
And Mr. DeBridger, do they work on your calendar?
Yes, thank you, Your Honor.
And Counsel for the State, I know you had raised a concern. Do those dates work at this point?
Yes, Your Honor.
Our new last day. Sure. While we're calculating the new last day, here's what I'm going to indicate. So that next hearing is going to be labeled a final trial management conference. Mr. Ruff, you do need to appear for every hearing. If you fail to appear, a warrant can issue. Then if there's a bond posted, it can be forfeited.
That's right.
And hearing, including trial, can be held in your absence. At that next setting, I expect to get a report as to whether or not your current counsel has received,
Objection, I do not have current counsel.
your current counsel has received discovery either from Mr. Lockhart or from the state. I'm going to ask that Mr. DeBridger be physically present or someone on his behalf
Yes.
physically present in the courtroom, and in anticipation that the court may entertain a transition for Mr. DeBridger to be advisory counsel and may entertain Mr. Ruff being able to represent himself at that next setting if Mr. Ruff complies with the court's inquiries and wishes to represent himself at that next hearing. In the meantime, Mr. Ruff, I am going to order that you have contact with Mr. DeBridger.
Now, what she just said was very, very important and very revealing on her thought process. She just gave me an order to contact this lawyer that I don't want to have contact with and that I don't consent to being my lawyer. But literally, the judge just gave me a court order to contact him.
Application was refused. That's
Yes.
what happens when you apply for something and you don't get it.
Yes.
Because you didn't cooperate at all and because you're a jackass.
Yeah. No, that happens all the time. I have been this guy down. Okay, so guys, if you're trying to figure out this lady with the kind of like Wilson Phillips, like I want to speak to the manager haircut and the glasses. That is the prosecutor. This guy who looks like he wants to chop his leg off is the public defender having to work with him.
Yes, if
Um,
you as a lawyer ever get saddled with a sovereign citizen because you've been assigned to help them out,
Mhm.
you've got ethical obligations to do your best. But holy
Mhm.
crap, will you want to just chew your own leg off to get out of that trap?
Yes, yeah, I've been this guy multiple times.
Yeah, it sucks. Thankfully, here they're often much more able to fire you, and so that's always wonderful. Although the exceptions are usually when, if it's like a domestic violence case or something like
Mhm.
that, they won't be allowed to cross-examine the complainant. So you can
Oh,
end up,
really? Huh.
yeah, because basically it's considered, improper for them to use that opportunity to beat up on their spouse or the victim of SV or stuff like that. Um, so, uh, yeah. So then you can get stuck sort of doing the cross examination.
Now, I've got actually in Canada. Do they do a standby counsel where you are prepared and you just the guy goes up and whenever he's done or tired of crashing and burning on his own, he gets to turn around and tag you in and say, "Okay, I want my lawyer to take over."
Not usually.
Okay. Because guys, that's actually a concept here that I've been this before where he wants to defend himself and the judge will say fine, but then the judge points his finger at me and says, Sean, you still have to prepare for this trial. So I prepare, I do all my research, I talk to all my witnesses, I get everything ready to go, and then I just sit there behind the table, along the bar, and he starts doing his thing.
That
And
sounds like
I've
the
had
best file.
well, no, but I have to be ready to basically jump in and start flying the airplane immediately as
Yeah, but this guy's
yeah.
never going to ask you to fly the plane. This
Oh,
guy's just going to
oh,
sit there
sure.
and you're going to get paid for being prepared and for, for doing all of the back end without any of the
Yes.
trial work or any of the,
Yes.
yeah.
So, yeah, but I have had to jump in before, and one time he started messing up in jury selection, so I took over from there. The other time we're about like 50 feet from the side of a cliff, and he's like, he's like, I'd like my attorney to. He says, Judge, can we have a timeout? And he said timeout instead of like, maybe we approach the bench. And he said, I'd like my attorney to take over. And at that point, the prosecutor had already gone through all of his witnesses and was on like the last two. And yeah,
So this is just, we're almost smashed into the mountain. And then it's his fault now.
yes,
Impact.
pretty much. That's pretty much what happened.
And then, of course, he's going to appeal and blame you for not the. So.
Oh, that I've had that happen. I've had that happen. Now, actually, Runkle, I saw somebody ask this question. I was going to ask you that. Are most judges bilingual? But it sounds like most are unilingual. Okay.
Yeah. So basically, if you decide you want a trial in French in most of the country, or in Quebec if you want one in English, normally you've got to indicate that sort of ahead of time to say,
yeah,
I'm booking this trial and I would like it to be in French, please. And then they'll assign a judge who speaks French.
okay,
But like most people here in Alberta speak English, so typically most of the judges are going to be unilingual English. The other thing is you can run trials where some of the witnesses, including the accused, speak things like Tagalog.
yeah,
And, at that point, you've got the trial might be in English, but you've got translators to make sure that, that it gets heard. So, yeah, all sorts of things.
Now, if they're First Nation peoples, like in Nunavut or way up north, do they get? Is it still English or French the only options, or do they hold trials in their languages? I
Still
don't know if you
English or
know.
French. So,
Okay.
yeah, there are people who definitely get annoyed at that when you're like, so you've got an option, the option of English or French, and they're like, how about Cree? And it's like, yeah, no, sorry.
Yeah.
We can have a Cree interpreter, but
Hmm.
that's usually only if you don't actually speak English, and sometimes that happens where you've got somebody who only speaks Cree, for example.
Okay. Kalberg, that's actually an interesting question. If you're pro se and you're on the stand, do you ask yourself the questions? No, and that's where it becomes an issue. If you have to take the stand, somebody has to ask the questions. Now, I don't know how it is up in Canada, but there are times where if it's kind of like a rinky-dink trial and it's not too terribly important, the judge might just say, okay, do you have anything you'd like to say? Go ahead. And then, the prosecutor sits there and chews them apart when they mess up. But yeah, that is a big issue. How do you question yourself?
I mean, self-represented people here don't typically question themselves. They just get
Yes.
up and, say whatever they want to say. So they
Yeah.
can go up and say, I'm going to start at the beginning. And,
Mhm.
it was Tuesday, July 8th of 1872.
Yeah.
And, I was at the Quickie Mart and I walked in to buy whatever. And, somebody else robbed the guy. And I was just standing there, watching the place going, being shocked about all of this.
Mhm.
So, he can tell the story as he wants and whatever details he wants. The one problem that they often run into is it's very difficult to address certain topics without basically confessing.
Yes, that's true.
Because, as a lawyer, when I'm going up and I'm addressing, my witness, I can say things like, this guy says you were, in the store at this time. If his defense is that he was never in the store, it becomes very difficult for him to say anything about what happened in the store
Mhm.
or, without, and that includes when he's questioning other witnesses, because he can say things like, any sort of, questions about what was going on in the store. Like, the lighting wasn't that bright, was it? Well, that makes it sound like you were there, which is
Mhm.
fine for
Yep.
if you're, if you're actually the lawyer. Nobody cares if the lawyer sounds like they were there. It just, at that
Mhm.
point, you sound like you just researched the case. But if the accused sounds like they were there, that's a real problem for the accused.
Yes. Yeah.
And somebody was asking if I speak French, un peu, mais pas tellement bien. So a little bit, not well. I would not be able to run a trial in French, but I was able to tromp around Paris and, order stuff without having to dip into English. So,
Well, there you go. Yeah. Biggest thing I remember from French class in high school was un gare and un guerre. Two very big different things.
well, and the other one that everybody always likes is, talking about seals in French. I take it you've heard the word.
Yes.
All right, let's watch this guy continue
Yeah.
to crash and burn.
Yeah. Oh, and real quick, Sweet Tooth, does the case start over again when you're standby? No. It's just like if a quarterback gets injured, you tag in and you start playing. So, here we go.
Now, I do have a bond on this case. If I violate a court order, she can revoke my bond and take me into custody. And then all of this is going to happen when I'm in cuffs wearing orange or stripes or whatever the current fashion is in jail. She's playing a game right now, trying to get me taken out of the courtroom in the manner that I am right now and put me there in a different manner. This woman is trying to screw me. I mean, if it ain't apparent I told her I will not talk to the lawyer, and then she orders me to do it and then puts it in the minute entries. So if I don't do it, the next time we come back to court and Ron DeBrigida says that, yeah, he didn't contact me, she can say that I violated a court order, revoke my bond, and take me into custody.
Real quick, can you identify yourself? I'm recording this conversation, so if you could verbally identify yourself so I have proof that I made contact with you today.
Certainly. This is Ron DeBrigida. I was previously appointed to represent you.
Awesome. Thank you. That's all I need. I already know what kind of stuff she's trying to pull with the last minute entry into the court when she told you to contact me, not me.
Wait, which she are we talking about? The prosecutor or the judge?
The judge, Vandenberg.
Oh, okay.
Mr. DeBrigida, what I normally would do, given that we're coming back on June 8th and you're still trying to get the discovery, is indicate that that needs to happen by the end of May. Does that work as far as an order for you and Mr. Ruff?
Judge cannot
Yes,
order
Your
me
Honor.
to speak to.
And you needed contact information from Mr. Ruff, correct? And so, Mr. Ruff, can you give Mr. DeBrigida at this time either a phone number or an email address which he can contact you at?
No, I'm not giving any of my personal information out to anybody I do not consent to have contact with.
Okay, so I'm going to make a directive at this point.
Got to protect that joinder, folks.
Violate my rights?
Give Ron DeBrigida, counsel of record, a means of contacting you either by telephone or through email.
Give me my email. It's copsgoneviral@gmail.com.
So is it COP?
I just said it. I don't have to repeat it.
You have to spell it so that he
It's
can actually
common spelling.
email you.
Common spelling, copsgoneviral@gmail.com.
Mr. DeBrigida, did you get that?
I did, Your Honor.
Okay.
And
so then
hopefully
I'll
so did a whole bunch of
direct,
spam bots when this went on
counsel,
YouTube.
Communicate prior to the end of May. At that next setting, the court will confirm
That's his
that
contact for his
discovery
YouTube
has been
channel, so-
resolved as far as what Mr. Lockhart previously received. Mr. Ruff, with regard to your ability to have counsel of your selection, you are free to hire any attorney that you want.
I could have my mother sit here and be my counsel if I want.
That's not correct.
That is absolutely
The
correct.
Arizona
Unless your
Supreme
mom's
Court
a lawyer.
Yeah. Yes, unless your mom, your mom went to law school, no.
And not the same law school he went to, which I think was in a cardboard box behind a dumpster.
Yes. Yes. And why is he being this way? Because he's a dickhead.
Yeah. Possibly organic brain damage. It's
Yes. I mean, he probably did go to public school, and I should talk because I went to public school as well. But yeah, public schooling is not that good here in America. So,
I mean, yeah, he's probably just a jerk. That is, and the other thing is that he's probably a jerk who's been taught that this is the way the court system in the world works, and he thinks he's being wronged, right? He thinks that he's being robbed here, basically, and he's wrong about that. He's an idiot about that. But
yes,
that that people will tend to act more like a jackass when they think that they're in the right, and somebody just needs to tell him that. Or he needs to somehow clue in that, in fact, all he's doing is eating paint chips here.
Yes. Oh, yeah.
Standards for someone to represent
You know, the
you
supremacy
in the
clause?
court of law.
The United States Supreme Court has
As
supremacy.
far
on
as
the Supreme
if
Court
you
of
wish
Arizona.
to represent yourself, you do have to comply to a colloquy where the court needs to assess whether or not that's appropriate. We did not do that today. I'm telling you that if you wish to raise that again at the next setting, we can go through that, but I am going to ask you a series of questions that include, do you read and understand English, which is what you objected to today?
I'm going to be appealing your decision regardless.
As far as, so long as you have assigned counsel, you are free to go out and hire an attorney, but the state is correct that you don't get to pick who represents you if the court appoints you an attorney.
Literally everything she's saying is wrong. Isn't it so entertaining to listen to people?
Actually, that's 100% correct.
And
we already covered that.
This guy's doing confession through projection again, as Viva would say.
Yes.
In power and authority that make lots of money spout stupidities on the internet. This stuff is great, and I hope you enjoy it.
Yes, she may be getting paid lots of money to spout stupidity on the internet, but
he's doing it for free.
Yes, you're not making lots of money here, dude. So who's fucking up in the game of life right now?
Oh, these guys.
As far as whether or not you can represent yourself, the court has to make specific findings, and that's what I think the state was wanting me to clarify. But let me just ask, is there anything else the state wanted to put on the record at this time?
No, Your Honor, thank you.
All right, so with that, we will come back on June 8th at 10 a.m. Mr. DeBrigida, did you wish to place something on the record?
I did.
Just that I will attempt to speak with Mr. Ruff, and if he does want to represent himself, I will assist him with that.
All right, with that, we will stand and resist in the matter.
I said
Oh, right, last day.
July 30th, 2022.
July 30th of 2022. With that, we will stand and recess in the matter.
I need your bond information, Vandenberg, or your oath of office, as well as the prosecutor and yours, Brigida. All of you are supposed to have a bond or an oath of office to perform duties for public. It's an
All right,
IRS.
so we are going to turn to number 5 on our calendar.
I just love how she just plows over him.
Yeah, the proper response to that is basically fuck you.
Yes. Yeah, well, thank you for watching. Well, at least he's nice to us.
So I'm guessing he just isn't going to tell us how this works out in the end, because
I don't know. Maybe he's at least he showed the whole hearing, because there's some of these sovereign citizens where I made fun of there's this guy in YouTube right now. His name's Chili DeCastro. Mike's done a couple of videos about him. I've done a couple of videos about him. And some guy challenged me to debate him, another sovereign citizen, when I looked at his channel.
No, that's never that.
Yeah. Oh, sure. But I just wanted to see what he had. And I looked at his channel and he's like, I got all the judges to run off the bench scared. And he's got like 4 minutes out of probably what was a 20-minute court hearing recorded. And that's the only part he plays. So I'm like, yeah, I'm sure what happened on the rest of it when you got cratered the whole time through. But yeah, I'm never going on their stuff. Fuck that.
Yeah, no, I mean, it's like sitting there going, I want to play chess with a chimpanzee. It's
Yes.
not going to, it's not going to play by the rules. It's just going to throw shit the whole time.
Yes.
It makes no sense whatsoever.
Oh, yeah.
And somebody in the chat was asking, do we have sovereign citizens in Canada? We do. Often they'll cite U.S. law, which is hilarious. The one guy I saw in court was just going on a rant about the fringe on the flag. And the judge eventually was like, sir. And, finally got the guy to listen. He's like, can you point to the flag in this courtroom? And he looked around because we're not as big on flags here. And there was just no flag. So he's like, okay, so if there's no flag in the courtroom, how can it have a fringe on it that's bothering you, sir?
Yes.
And
well, actually, if he was smart, then he'd be like, well, then I don't know what jurisdictional laws we're being under if there's no flags here.
Yeah, that doesn't work either.
I know, but I give him some credit. That's so, but yeah, some of them, and I mean, I'll give him credit. He put the whole hearing up, but yes, he probably sits there thinking, oh, I showed them, or I've got them right where I want them, and the appeals are going to be great. But that's interesting. The ones I've seen of the Canadians, I didn't see them citing U.S. law, but they just keep citing common law, and that's really been it. But that would be hilarious to watch them cite U.S. law.
I mean, sometimes they cite like the Uniform Commercial Code and that kind of stuff.
Oh,
and yeah, that's always just like. Although the thing is that Canadian TV is basically like U.S. TV for the most part. You turn on the TV and you're going to see the same shows here as you see in the States, and so all of our court dramas are U.S. based. And, all of that. And the other thing is that the U.S. televises a lot of trials. Canada televises basically no trials. So almost all the time what we'll see is people will go into court and they'll, stand up and say, oh, well, I want to cite my First Amendment rights. And the court is just going to be like, oh, you do you? Do you have any such rights? Because you don't.
Well, I guess though the funny part would be if he said, if they all wanted to be cheeky at all, he could say, well, I could cite my rights under the the Charter of Rights in Canada, but I know those aren't existing either.
I mean, we do have a Charter of
Well,
Rights.
no, I know, but he could say
Yeah.
like you're probably not going to respect those either.
Yeah, that might be a better sort of better argument for that. But
Yes.
yeah.
Oh, the one thing. Oh, so hold on. Nero said something. The articles. Okay, to be fair, the Articles of Confederation. I mean, technically, the United States Constitution and the Constitutional Convention, the first one, was technically kind of like a coup. They literally just came out and said, "Sorry, we're following new rules." They didn't actually abolish the Articles of Confederation, technically. So, I mean, that was the sketchy part about the whole thing, but since everybody accepted it, it was considered legal. So that's one part they get right, but then they completely go crazy after that.
I mean that. Yeah.
Yeah. Oh, do you guys have moors in Canada?
Occasionally, yep.
Oh, really? Nice.
Yeah, and we also there's at least a couple of guys who have their own sort of weird variants of Moorish law, and one of the really fun ones was this is a guy who keeps signing stuff in blood, and
Ooh, that's not
yeah,
good.
which of course is wonderful when it's like, oh, good, opposing counsel is getting this document that's now a biohazard.
Yeah. Oh, he does. Oh, I forgot. He does have a couple more. It looks like. Judges aren't allowed to do this in court, but it looks like it's all from the same. I don't know if it's the same hearing or not. But yeah, he doesn't like. Yeah, I'm sure he thinks he gets one over on all these cops every time he interacts with them.
Oh, and I mean, these guys usually think they're winning right up until they're like, "What do you mean? I gotta pay?"
Yeah. Oh, thanks for the dried AIDS. Yeah. Do you get? Does the guy have bloodborne issues that he signs in blood?
No, there's another guy though who we at one point had a file with a guy who had some serious bloodborne diseases, and those also caused him to have sores. So a lot of documents that were extremely biohazardous and basically had to go into a bag and get triple sealed. And it was like,
ooh,
yep, these are not to be opened. And if they are to be opened, set down a tarp, handle only with gloves and mask and whatever else, because real bad shit. So
yeah. I have anything that bad. I did have one guy one time though. He was just really nasty though, and kind of grungy, and just everything. Like when he touched stuff, it was all one-way transaction. If he needed, like, hey, what about this, or can you get? I would figure out what kind of document it was, and if I could obtain it on my own, I went ahead and got it on my own. I didn't want his papers at all.
Yeah, no, it's always fun stuff.
Yes. Oh God, what is he? Is this the same hearing at all?
And Judge, my client asked me to advise the court that he's making a.
Oh, this is the. Oh shoot, this is him actually coming back to court.
All right, well, we got to find out how this ends.
Oh, do you want to stick around? I didn't. Oh, I forgot you were a couple hours behind, so it's.
Oh yeah, no, it's not too late.
Okay. All right. Well, I guess, guys, if you can handle more cringe, I guess we're gonna keep going here. Oh, let's see what happens.
And Judge, my client asked me to advise the court that he's making a recording.
No, that's not permitted.
Okay, we're gonna skip ahead.
Okay. We'll go on the record. This was grudge number 11 on the calendar.
See, now this is nice. He actually gives like the case caption, things I can look stuff up with. Like it's a little better now.
CR 2021 11 73 15-001, and if the state can announce for our record.
Good morning, Your Honor. Jane Schneider for the state, appearing virtually.
And defense counsel?
Ron DeBrigida, appointed counsel for Mr. Ruff. And Judge, my client asked me to advise the court that he's making a recording.
No, that's not permitted.
Rule 122.
It is not permitted.
Why not?
It is not permitted.
And you have the rules in front of you. 122.1, subsection H.
Now, yes, you're not allowed just to come in and record. Courts are worried you're going to come in and misrepresent stuff, cut things out. I think some of this is a court. They want to be able to control the situation in the room, but that's. Somebody's asking about. Somebody's asking about Ricada. Yeah, the entire stream with him and Fudbusters, Matt LaRosiere, that entire thing got considered violent content. So, I don't know. He's going to have to get that sorted out.
I don't know what's going on with that. I haven't.
Yeah,
been following that one.
He got a channel strike. So.
Oh, geez.
Yeah, he got a strike for that. Yeah, but here's the thing, though, Eric. Fuddbusters has had guns in his background forever. He's got all kinds of stuff on the wall. So
Yeah, they don't want you having that on a stream though. Well, they don't want you
yeah, well,
handling it, so I don't know.
he didn't touch anything. So
Yeah, I don't know.
okay, yeah. But anyways, we'll just keep going. I'm sure he's properly cited all this. Oh, yeah, notice how he went really fast past this part here. You must notify the judge's staff prior to using the device.
Yeah.
Yeah, notice that, notice he just glossed over that super quick.
Of course he does.
Yes.
So, Mr. Ruff, if you do not terminate that, I'm going to have you removed.
Also, usually the judge has discretion to allow or not allow.
It's awesome.
Yeah.
What are you doing?
Oh, sorry, real quick. I got a super chat. Seth Harvey for $5. Where's that at, Seth? Oh, there you are. For $5. Thank you very much. I appreciate this. Thoughts on Steve Dettelbeck? Better than Waco Dave, but extremely milquetoast. Steve Dettelbeck is the new ATF director. No, he's a scumbag. I mean, even in his stuff, he's like, "Oh, I've never handled guns. I really don't touch guns." Then why the fuck are you in this job? And the answers he gave are going to be the most milquetoast, normie answers to get him through the committees. You know, it's not like the ATF is going to change. They're going to keep doing what they do and do even worse. They've got all the rulings that they're going to start dropping on us. So no, it's not going to get better. He's a scumbag. He was a scumbag here in Ohio when he ran for attorney general. Fuck Steve Dettelbeck. He was atrocious back then. He was going to dick with the CCW system here in the state because the attorney general supervises it. No, the guy's bad news. Completely bad news. But yes, he's better than David Chipman. But that's not saying much.
So you're violating my rights in open court. That's a Fourth Amendment violation. Taking
Mr.
my
Ruff,
stuff.
can you please state your true name and your date of birth?
Welcome to my world, people, where the people that we pay big money to don't play by the rules, and most of the time they don't even know the rules. I literally quoted the rules to this woman, and she told me to turn it off. I turned it off.
That you didn't follow.
And yet a judicial security guard just walked up and is going to take it out of my hand. So you don't have a Fourth Amendment in a courtroom anymore?
I mean,
So
you don't
recently,
have
the
lots of rights
news
in
in
the courtroom.
Arizona got behind
Try exercising your
trying to
second in a
stop
courtroom.
HB 20.
Yeah, you don't. Now, yes, is that a seizure? Certainly they seized your items, but you probably get it back. So you let your phone ring in a courtroom. You'll figure out how strong your Fourth Amendment is then.
319, which would limit police recordings because they're trying to tell us where we can stand and they're trying to create a legal distance that you can record them from. Well, the news agencies got behind it because they quoted it would limit legitimate police coverage. Well, what happens when you guys try to go into a courtroom with an audio recorder, which we've been doing for so long, and try to audio record somebody's court proceedings after you inform the judge and this happens to you? I mean, if you're a reporter, this should scare you too. It ain't just going to happen to me.
No, it'll probably just happen to you because the reporter will do the right, do it the right way.
I will just note for all individuals who are in the courtroom, you are.
Yeah, court reporters, guys, they are all the ones I've ever asked. When it just goes in one ear out the other. They're literally like on autopilot. Whatever they hear, they will type. So there is no. They selectively put stuff in. They just, if it's said and they hear it, it gets put down.
Are not allowed to do any separate independent recordings of these proceedings. If you need a recording, you can contact the FCR department for a recording of the court's official proceeding.
FCR is for the record.
Mr. DeBrigida, when we were here last, I had directed that your client have contact with you, and I wanted to confirm today that you obtained discovery. Did
I
you
did
obtain discovery?
I did obtain discovery from previous counsel, and I have spoken with Mr. Ruff since the last proceeding.
And then how do you wish for us to proceed today?
Judge, my client has asked me to re-urge his request to represent himself. He seems okay with me being appointed as advisory counsel. If the court will permit that, I'm happy to do that. I also am advised that there was a notice of appeal by special action filed by Mr. Ruff. He did file the original, correct?
Mm-hmm.
And I have copies for the court and counsel. I don't know if either have received it.
I have not received it. Is this special action with regards to?
Regarding representing himself.
And when was it filed?
Looks like yesterday.
Mm-hmm.
May I approach this?
Well, we don't have the ability to approach.
Oh.
So,
I don't want to toss it
all
over
right,
your...
so we'll
And guys, just so you know, if you do want to represent yourself and you feel like you need to file a motion, don't wait till the day before you show back up to court. As soon as you can get it done and put it together, get it filed.
Yeah.
Because
all applications do better early on than late.
yes,
So
it's better than showing up the day of and saying, "Oh, I just filed it," but it's not much better.
we'll note that special action, but given that the Court of Appeals has not yet made any proceedings on that, the court will simply note it for our record.
You know, something that I've noticed, and this is the second appeal that I filed. Now it's a special action, but something I've noticed is these people don't even know how appeals work. I went and filed this appeal exactly how I'm supposed to, but my lawyer and the judge are thinking that I'm supposed to file it with the appellate courts. You're not supposed to file that stuff with the appellate courts. Here's a video. I called them and asked them.
Yes, you have to. It's a final order. You are not allowed to represent yourself. So, who are you appealing it to?
I am trying to find out if you guys have an appeals number for me yet. A case number.
Okay. Just one moment.
Okay.
What type of case is this?
It's a criminal case in Superior Court.
When was the notice of appeal filed?
Oh, let me check my photos. April 20th.
I don't show it. You probably should check with Superior Court.
Well, I'm calling because I got a minute entries from the judge that's saying that that there was a motion or a notice. I filed a notice with the Superior Court. The notice with regards to an attempt to appeal the court's decision says I'm free to file whatever I want, but that I need to file it with the appropriate court. So they're saying that I didn't even file my notice of appeal with the appropriate court, and I submitted it with the Superior Court. Is that correct?
That is correct, yes.
So I don't understand what's happening here.
Well, like you said, those were probably done in Superior Court, so you need to contact Superior Court.
Mm-hmm. This lady may not sound like she's helping him because she cannot give legal advice.
yeah.
And even if she was an attorney who was there, they're not going to give you legal advice. They're going to tell you, go back to where you filed it, and you're going to have to figure it out from there. So she's trying to be really nice at saying, it sounds like you screwed up. You need to go back to the start and kind of retrace your steps.
Okay, I know, but if I'm contacting him, what am I? I'm not trying to be like an asshole or anything. I'm
Oh, but you're
extremely ignorant, so that's why I'm asking. Like, what?
She's not wrong.
No shit, you're extremely ignorant. No shit. But once again, they can't give you legal advice. Just like if you go to the clerk and say you're trying to file something, they can't give you legal advice. So what are you supposed to do? She can't tell you. That's not her job. She legally can't tell you.
What am I asking them? I thought they were supposed to send you guys in like the notice that they got the appeal, and then I was going to get a case number from the appeals court.
Yes, and they haven't done that, so you need to reach out to Superior Court.
And see why they're saying that I didn't file the right paperwork?
That is correct.
Now, feel free to pause this and read it very, very carefully. She indicates in her minute entries that I filed a motion to reconsider as well as a notice of appeal. She said the defendant, through counsel of record, is free to file whatever requests for appellate review in this matter appropriately, but said findings must be done with the appropriate appellate courts in order to initiate such a review rather than the Superior Court of Maricopa County. Holy crap, you just listened to a phone call where the appellate court said I had to file it with the Superior Courts.
No, they didn't. They said
No.
you
Yes.
had to go back and ask them what the hell you did wrong. They
Yes.
said basically go back and
Mhm.
ask them what the problem is, and you
And-
are willfully misinterpreting that because you're dumb and
Yes.
you are a jerk.
Yes.
And yeah.
Well, and I don't know specifically Arizona, but in Ohio, for example, if I want to appeal something, you don't go to the appellate court and file things. It doesn't work that way. You have to go through the county court you're in, and you file the appeal paperwork there, and they kick it up to the court, court of appeals from there. And that's how you go and file things. You don't file directly with the appellate court, and I think that's probably the issue here. And he just doesn't understand that. And once again, he thinks he knows something, but he's clearly missing it. So yeah, this is just a motion to reconsider. You generally don't have those on rulings such as this. Now you can ask the court for a motion for a new trial, but if the court's denied your motion for X, Y, and Z, a motion to reconsider, I've seen these tried to be filed before. Judge says, sorry, Lamau, denied. I already said no. So yeah, this is just a guy who doesn't understand what's going on.
So somebody doesn't know what they're talking about.
Correct.
Yes.
And she said, given the substance of the April 21st pleading, the court will consider such a notice for the record and take no further action on said pleading. So I submitted a notice of appeal with the Superior Court of Arizona. She recognized that in her minute entries and is still going to deny it and not submit the case paperwork to the appellate courts to start the appeals process.
Because you didn't file it right.
This is not okay.
We'll also note that that was filed pro per, and while it's not a question before this court, it's unclear as to whether or not the Court of Appeals will entertain it, given that Mr. Ruff has counsel of record.
What she's saying is because I filed it pro per and they have identified counsel for me against my will, that she doesn't think that the appellate courts is going to entertain it because I have an attorney on record. Even
Which is in fact what the order says is that it should be filed through his counsel of record.
Yes. And that is called hybrid representation. You can't do that.
Yeah, and I mean that it's perfectly fine. You can have the lawyer say, "Hey, Mr. So and so would like to be removed as counsel of record."
Mm-hmm.
That is perfectly acceptable, and yeah.
Let's let him keep going. I like his Grand Theft Auto sweatshirt. I wonder how much that cost him.
Probably.
Even though I've clearly stated that I want to represent myself. That's why I'm even filing the appeal. This appeal is on her decision to not allow me to represent myself. This woman is crazy. Crazy.
Having said that, so Mr. DeBrigida, you're asking that I entertain Mr. Ruff's request to represent himself. I did issue a minute entry on May 11th of 2022, indicating that the rule does require a written motion, and the court did cite the form that it directed to be used. Has that already been completed by your client?
Okay, so what's happening is
so
now
he was
she's
supposed to follow
realizing that I know how to
directions.
use special action appeals and appeals to appeal her decisions that she's making in court to violate my rights. And now she's flipping the script and trying to introduce a form that the court uses to show that you have knowingly and intelligently waived your rights to counsel in order to represent yourself. You don't need to fill out this form. This is like submitting a public records request without using the form that they provide and just sending.
Actually, no. If you want to waive your right to counsel, you have to do it in writing. No court's just going to let you do it verbally. You're going to have to sign and check the boxes off saying, I understand I don't want an attorney. I understand this is a bad idea. And I'm signing it here in court. So, no, there's actual forms you have to sign for that. I don't know how it is up there, but Critter, you're going to go. Have a nice night. Thanks for being here, Critter. I appreciate it.
Often here they'll let people do it just on their own, but
yeah, but usually, I mean, here there's always you pretty much always do written. Just it makes the record that much easier.
Sending an email, which is completely legal. I don't have to use the court's form. I submitted
An email is not going to cut it.
Yeah.
Because the minute he goes into court on his appeal, he'll say, you can't prove who sent that.
Motion to represent myself pursuant to courtroom rule 6.1c, knowingly and intelligently waiving my rights. At the end of this, you'll get to see
We'll
that
come back
motion
to
that I
that
filed.
this
And
evening.
this is the motion that the court is saying never got submitted.
1 second, please, Judge.
Yeah, that's the one you didn't submit properly and file properly.
Motion to waive my right to counsel to represent myself, 6.1c.
Reverse counsel form. Yeah. Do you have one? Thank you.
Right.
I'll get to this one, Melvin.
It's not required legally. All I have to do is submit a motion knowingly and intelligently waiving my rights. Okay, Judge, as I understand it, if I'm hearing everybody correctly, my client has filed a specific motion to represent himself, but as I understand it, has not filed the form that is commonly used by the court. Is that correct?
Are you asking me, Mr. DeBridget, or your
Asking
client?
everybody, but mostly my client. He indicates that he has filed a motion to represent himself, but has not used the standard form that we're familiar with.
Can you give me a date in which he has filed that? Because I have not received such a document. I will tell you and note for a record that the documents that this court has received were referenced in the minute entry from May 11th of 2022. And as referenced, the court received first a document filed April 20th of 2022 labeled Motion for Reconsideration to Arizona Rule Criminal P 6.1c, Defendant's Waiver of Rights to Counsel, which the court then in that entry referred to as the April 2022 motion. The court then also received a document filed April 21st of 2022, filed by the defendant labeled Motion for
I like that little wave to the camera. That was so stupid.
Consideration pursuant to Arizona Rule Criminal P 6.1c, Defendant's Waiver of Counsel, which the court then referred to as the April 21st, 2022 motion. So those were the documents the court received and has ruled on. I will note that prior to the last setting, Mr. Ruff had indicated that he had filed a motion, and that was a discussion that was held on the record on April 12th, that the court did not receive a written motion. So the court, in anticipation, and actually told Mr. Ruff,
yes, he's photoshopped the judge to be a dick.
Consider any future motions to represent himself. The court indicated that it would entertain such, but it would be following Criminal Rule 6.1, and indicated specifically on page 2 of that minute entry that this court would require and has the authority to require that any such request would need to have the waiver of counsel form approved by the clerk of court, referenced as Form 3899-079, R09-01. Mr. DeBridget, if you want the court to provide that to you and your client, I'm happy to let you all take a brief recess to go over it, but the court will require that form, and I will just note that the court will require Mr. Ruff to participate in the standard colloquy in determining whether or not if he can knowingly, intelligently, and voluntarily waive his right to counsel.
The only part of that she got right was knowingly, voluntarily, and intelligently waiving my right to counsel. And I submitted a motion doing just that. She wants me to fill out a form and sign a contract with the court agreeing to colloquy.
That contract, oh no, joined her. Dun dun dun.
Yeah, these guys are always this notion that like a court order requires some sort of agreement or contract. No, the whole point of the court is that they can order you to do stuff that you don't agree to do. Like, hey, neighbor, owes me money. He doesn't want to pay it. Court can order him to pay the money because that's what the court is about. Like,
and his waiver, if he thinks his waiver means anything, he's already signed something and submitted to the court, so he's already contracted with the court. He's already made an agreement. But don't let me. I'd love to hear his answer to that as he stared at me and blinking aimlessly. Guys, no, the lady's not dead. He just photoshopped some cringy campaign photo of her over her picture in Zoom just to be an idiot. So,
and all kinds of other stuff that I don't have to do, but
the judge said you did.
She wants me to do. This paperwork is not required by law to represent yourself. Nowhere in case law does it say I'm required to fill out court paperwork. I just have to knowingly and intelligently waive my rights. One of the ways to do that is through their paperwork that they're trying to provide. But it also...
Yes,
the court's entitled to require you to do things in certain forms. Like they do this all the time. So,
he's almost there. Once again, he just barely, just one more shovelful, he'll get it.
So ropes you into a contract with the courts and you agree to do a whole bunch of stuff. I don't need to do that. This is America. I'm allowed to represent myself. But it's not going to happen. Watch.
All of the stuff.
Would you like that form?
I would like that.
I will also say his editing skills are a lot better than mine. So
he is doing a good job on the editing.
Yeah. I wish I was that good.
I'm going to ask my CA hand that to you. We'll take a brief recess when you're ready. All right, so we are back on the record, and this is with regards to number 11, the rough matter, CR 2821, 1173-15-001. We'll note that the state is present virtually. Defense counsel is present. Mr. Ruff.
That prosecutor has some carrying eyeglasses.
We took a pause for you and your client to go over that form, and so where are we at with him?
Pleasant. I give my client an opportunity to.
Oh, I bet she's nice, but they're just carrying glasses.
The matter with Judge Fox, who sends his appreciation, by the way.
Not very attractive.
Mr. Ruff did have the opportunity to review the form. He does not wish to sign it. It is his position, and I'll let him elaborate, that that form is not required for him to exercise his right to represent himself. Is that correct?
Oh,
so
you can feel this lawyer's soul dying as he's got to deal with this crap.
A challenge to this court's ruling denying his
I feel his pain in his voice.
Himself. I suspect at some point that issue will be taken up by the Court of Appeals. Where that leaves us for today, I would certainly want to request a continuance of the trial date in any regard because of where we're at. I'm still relatively new in this case. I have had the opportunity to review the disclosure materials. I understand at least what's being alleged with respect to the underlying charges. In a normal course, I would certainly want to have continued discussions with my client about how best to defend against those charges. But I also respect his right to represent himself, and I don't want to infringe upon that in any way.
Well, okay. So, Mr. DeBridger, I appreciate that you use terminology that Mr. Ruff has used. But as you know, and as the court's minute entry from May 11th indicates, a defendant does not have a constitutional right to represent themselves. They have a constitutional right to be represented by counsel.
That one statement alone should scare you. You can support the police all you want. You can support the government all you want, but that should scare you. If you're not a part of the government, if you're not a police officer, that goes for you too. That goes for you too. Keep supporting them. Keep sending them your money. Keep showing them your love. They don't care about you or me or your family or anybody else but other government officials.
Okay, yeah, I do agree with that part, yes. The government is not your friend. They're not here to help you. But
Oh, come on. We're from the government. We're here to help.
Yes.
I don't mind.
Yes. Yes, I know. They're here to help you just like a Valdi police officer.
I'm also willing to help people in the same manner as the government. Drive up, take their money, and
Oh, I got a super chat from Minor Zircon for $2. Thank you very much. Hey, it's my favorite elf.
I have got to get a proper costume together for Halloween.
Yes.
Because that's coming up.
Yes. Oh, also somebody I had it, but I accidentally removed the starring on it. Somebody asked, "So when are you gonna join Viva down in Florida?" So at some point.
I don't have the same sort of inroads that Viva does, and also I kind of like Canada. I'm just hoping Canada gets back to sanity in a bit.
Understand. Somebody was asking, so. All right, here we go. We'll keep going.
What more proof do you need?
Now, the court can, under certain
know some evidence?
circumstances, make a finding that a defendant has knowingly, intelligently, and voluntarily waived that right to counsel. But terms matter. And so when we keep saying that a defendant has a right to represent themselves, I'm going to politely every time disagree.
Are you worried at her statements yet? Because you should be.
That is not what the Constitution indicates. That's not what case law indicates. And I want to point that out because I'll just affirm what I indicated in my ruling from May 11th, and that's that if a defendant wishes to waive their right to counsel, they must submit themselves to this court's directive. This court has the authority and the ability to require certain things that will promote the orderly, expeditious handling of cases. This court ordered that if the defendant wishes to request a waiver of counsel, the defendant shall comply and review the waiver of counsel form, which we did provide. That's rule form 3899-079 R09-01.
That's a lot of. Geez, that's a
The court also,
big form
by
title.
case law, will require a colloquy where the court will ask certain questions to determine whether or not the defendant has knowingly, intelligently, and voluntarily waived their right to counsel. Mr. Ruff, if the issue is that you are uncomfortable reading that form, then I'm happy to have us read it aloud together.
Oh gosh, I don't really think he is, but oh my god, that is beautiful. I only heard the first one. I not heard the second one. Oh my god, I love this judge now. She's just fucking with him back.
Yeah.
It's okay if you don't understand. If you can't read, I'll help you. Oh, Minor Zircon for $2 again. Thank you for the super chat. Runkle, you have to escape Canada, brother.
It's not likely to happen anytime soon, but
Yes.
we'll have to
Yeah.
see where things go.
And it's not as simple as just floating a car across the river, like in Cuba.
Yeah, that would be impressive as well.
Yes. Hey, if you could make it across Lake Erie, I'll help you out.
That might be fun just to do as a protest move, is float a car across the lake.
Yeah. Well, hey, and the neat thing is, it's the shallowest lake, so
I suspect that there'd be environmental issues around that. It'd probably get dinged for a whole bunch of Lake
Erie's. I mean, I live in Cleveland and the river caught fire, so you can't make it too bad.
Fair. Yeah, don't burn the river, people.
Is that the issue?
Yes.
That caused you not to wish to review and sign that form?
Are you insinuating that I can't read, Your Honor?
I asked you a question, Mr. Ruff.
I don't
Yes or
understand your
no?
question, so I'm asking you another question to clarify. So are you insinuating that I can't read? Or what are you
I will
asking?
ask my question again. Did you fail to sign that form because you were unable to read it?
Are you asking me if I can't read
It's
or
a
if I
yes or a
read it?
no.
I don't understand your question.
Okay, so at this time, again, the court will affirm that it's not been provided enough information to make a determination whether or not Mr. Ruff has knowingly, intelligently, and voluntarily waived his right to counsel. As I indicated previously,
He's too stupid to realize she's fucking with him.
Yeah, and doing so gloriously.
Yes, and she's in a way that does not look offensive at all. Oh God, that is beautiful.
I will just note that case law Deck v. Missouri reaffirms that the Supreme Court of the United States has affirmed that an individual does not have the specific right to represent themselves. However, if they prove themselves to be capable, they may defend themselves, but they must comply with basic rules of court. Given the conversation we've just had, the court does not find that there's been a demonstration that Mr. Ruff is capable of doing that. At this time, the court will deny his request to waive counsel. The court will affirm that Mr. DeBrigida is counsel of record. I will continue to indicate I am happy to entertain future requests to represent, to waive counsel and represent himself. However, he must comply with Arizona Rule of Criminal Procedure 6.1c and this court's previous orders as articulated in the May 11th, 2022 minute entry. I will note that that minute entry was then reissued based on a clerical error on June 2nd of 2022. Having said that, Mr. DeBrigida, as far as your request to continue this matter, how much time are you asking for?
You have a moment, Judge?
Yes.
So,
Since it's if you want to represent yourself, you have to demonstrate you understand what's going on. I mean, because like if you can't read or write and you can barely understand the spoken language, it would make no sense for you to represent yourself. I don't know if you're being sarcastic, so I'm trying to answer this seriously. He claims he doesn't want to sign these documents, but he's not telling why. He's refusing to sign or read the document. But he's not saying because I don't want to establish a contract. He's just saying, no, I won't do it. Well, the court has to assume you because you can't read it. And they're asking, well, is that the reason why? And he won't answer them. So until he explains why he won't do it, the court has to assume that it's just he can't do it. This is just, he's not smart enough to, talk his way through things. And if he did, he probably would be fine. But he's just not bright enough to get to where he needs to go here.
Well, I mean, if he said, I don't want to form a contract, they'd say that's stupid. That's not.
Sure. And maybe he truly knows that if he mentions all that, the judge is just going to laugh at him. Or, I mean, I think really it's just he didn't know at the time what to say. And when he's doing the video later, he's had his chance to collect his thoughts and say, yeah, I'll give it to her now. But, hold on.
Possible.
Yeah. Is this why lawyers drink? Sometimes.
Yara, what case law did you just quote?
Yeah, that's a good idea.
It's all in the minute entry
But you just quoted
dated
case
May
law?
11th of 2022. That was then reissued on June 2nd of 2022.
It sounds like practicing law from the bench. That's why I'm asking.
Oh, that sounds like some crazy government conspiracy stuff. Practice of law from the bench by a judge.
They are the finder of law. That's kind of their job. I mean, holy shit. Like, what? I mean, are they not allowed to do anything, buddy? Like, come on here. What?
Yeah, I don't know. He's
I mean,
he's got
come on.
notions.
Yeah. But no, I'm just Googling Deck v. Missouri because I've heard that case before, but there were issues. The guy was shackled during court. I knew that it was a death penalty case, but I didn't know if that's I'm assuming the judge is correct if she's citing Deck v. Missouri, so I'll leave it alone. But that is a real court case. In case you guys are wondering, and yes, I use Wikipedia because it had popped up, but it is a real court case. So, but anyways, we'll get back to the fun stuff.
Yeah, my lawyer thought the same thing, and I even quoted 28,454.
So he is your lawyer? I mean, you just said my lawyer, so it's almost like you're trusting him now. I don't know. You be careful. It's me using that sneaky lawyer talk, I guess. Oh, hold on here. Squabs for $5. Thank you very much. I appreciate the super chat. Sob sits are fun to laugh at, but Mountain Man versus Cop Judge, I'm rooting for the Mountain Man all day. I was hungry. I got food. Great. Oh, I've heard that guy. Some guy up in Montana. He was like, I was hungry, so I went fishing. It's like, yeah, I get that one, but why no Westlaw? Because it's quicker to do this than Westlaw. And besides, you guys can actually access that. You guys can't access Westlaw. And I actually use a different service than Westlaw or Lexis for things through the state bar. So,
For USC, practice of law from justices and judges from the bench is a misdemeanor. You didn't even know what I was talking about, but let me show you some things.
hold on. Whoa.
Practice of law from the bench. Well, that sounds like some crazy government conspiracy stuff. Practice of law from the bench by a judge. Yeah, my lawyer thought the same thing, and I even quoted 28,454 USC. Practice of law from justices and judges from the bench is a misdemeanor. You didn't even know what I was talking about, but let me show you some things.
That's not what that says. Also, that's federal, but any justice or judge appointed under the authority of the United States, so meaning federal courts or the federal jurisdiction, who engages in the practice of law is guilty of a high misdemeanor. That just means if you're the judge, you can't go out and practice on your own.
You can't run a firm, which is, of course.
Yeah.
But
Yeah. If I'm a federal judge, I can't go down the street to the Cleveland Municipal Court and go litigate a traffic ticket. That's what that means. But yes, I'm sure he would be upset if you pointed out judges are the finders of law. They determine what's legal. They determine the law that applies. They determine the proper procedure. This is once again he's trying, but oof.
he's trying a lot of things, mostly patience.
Yeah. It's just like Mr. Meeseeks. Oh, he's trying real hard.
And here's the original document with a little bit more context.
Oh, and we've just got you on the video.
Oh shit. Oh. All right, there. Okay, yeah, here. The original text. We're doing original textualism. I guess this guy likes Clarence Thomas.
Somebody has to.
Yeah. Once again, you cannot engage in the practice of law. Once again, on your own.
Yeah. He doesn't understand that at all. All right, let's keep going and see if this gets any better.
Yeah.
Or be engaged in the practice of law. Now, if you didn't catch it, she quoted case law while she's on the bench. It's not the judge's job to quote case law. That's the prosecutor's job. The judge is practicing law from the bench.
No, you are an idiot.
Yeah, like if you give, I mean, even if your argument was correct, the judge has to agree with one side or the other. So
the judge has to know and rely on law. Like
yes.
Why do you think we have a judge who's got a legal education and not just like Rando the bear off the street?
And guys, I think I said this before. I think I said this on Law and Lovers channel. This is the best system we've put together for being a bunch of like half retarded monkeys that figured out how to wear pants. That's true, but like, yes, this guy's he's just a monkey who figured out to wear pants. But I think he's like completely retarded because this is just bad.
Are we sure he's wearing pants right now?
You might not be. It's Arizona, so it's a little warm down there. Yeah, or a lawyer dog. Yes, yes. Maybe a
Oh,
dog.
well, that was the that case was just egregious.
Yes, getting a
Everyone
dog.
involved in it should be, thrown into the sun.
Yes, very 100%.
Oh, he wants a lawyer. Like,
Eh,
come on.
yeah. Yes. Yeah. Oh, he didn't say it specific. He wasn't clear enough. And like I said, the moment that judge said, "Well, maybe he meant a dog who passed the bar," he should have been removed because if he truly thought that existed, I have questions about his competency and
Well,
fitness
I
to
mean, it's
serve.
just so obviously that he's just making a
Yeah.
decision that
Mhm.
is very motivated reasoning, and that it's one that can't be like that lawyer dog thing can't be reconciled with any sort of common sense.
No, I can't. But
It's like,
if that's what if he's trying to be serious, then I'd say, Judge, I think you are mentally and cognitively impaired. You should step
that's
down.
probably being generous.
Yes.
There's plenty of people out there with
Yeah.
various serious impairments who manage to still figure out like simple sentences like that.
Drew's saying he knows a guy who got arrested for giving legal advice to an auto accident victim that opened his eyes. I'm betting, Drew, he did a lot more than just give some advice. To get in trouble for practicing law without a license, you have to do a significant bit. So I don't think it was just saying, "Oh, you should get an attorney," or "Oh, that definitely is, something you could sue for." You have to work hard at that. So there might be a little more to that story than you've been told. Oh, my interesting says sweater pants. Oh, he actually had a super chat for you also. Just go to Mexico and walk up to Texas.
I feel like Texas is a bad place to screw around.
Yeah, you can cross Arizona somewhere else. So, anyways, let's see where else we're going here.
What's the old line of "Don't mess with Texas"?
Yes,
I feel like that is probably good advice.
yes.
There ain't no question about it.
Agree. So, Judge, I see our current trial date is June 28th. I know that's not realistic for a number of reasons. And then also I will not be available the week, well, I guess it would be that week that covers the middle of July. So I would ask that the trial date be reset until after that time. I believe we're willing to waive time to allow that to happen.
Yes.
My client's indicating yes. So that's my request, Your Honor. And
So
I
that-
apologize that I don't know how many prior continuances of the trial there have been since I was appointed.
The first hearing that you appeared at was on April 12th.
Okay.
And so you're saying that you want the trial date to be like the week of July 18th?
Right. It would have to be that, yes, that I would be back from my leave at that point.
Are you prepared to do the final trial management conference today? I mean, you indicated that you've reviewed discovery. It sounded like you and your client need an opportunity.
No, I would ask that be reset for perhaps the beginning of July or second week of July.
Okay, Heather, do we have availability the week of July 11th to do the FTMC?
Your Honor, I'm sorry to interrupt, but I am unavailable the week of July 11th.
So,
And I did not mean to exclude counsel
Sure,
for the
right.
state from the
Yeah.
discussion of availability.
so the week of July 18th for an FTMC, Heather. July 19th. FTMC. So then we would be setting trial, that date works, for August 2nd. Okay, so final trial management conference here with this division, July 19th at 10 a.m., trial August 2nd at 9 a.m. with the master calendar. Do those dates work for the state?
Yes, Your Honor, thank you.
I got to run in the bathroom. We'll be right back.
Fair enough.
Runkle, you can mind the store.
I don't have any powers to make things go and not go, so all I can do is hopefully keep people from getting too bored. All right, chat, if you got questions for me, this is a good time for that. Oh, I see somebody saying restarting New Vegas Legion playthrough this time. I can never actually do a Legion playthrough. I am too much of a softie. When I run it, I always just am like, I find most of the factions to be just too miserable to to tolerate. Somebody says, what order of magnitude of firearms do you own? I own less than 100. Somebody says, when's my next live stream? I don't know. I don't have sort of grand plans for that. Oh, somebody wants to see the sword. Which one? I've got multiple swords. So there's several options there. Somebody was asking, do I still do leather work? How much for a wallet? I do still do leather work, but I have never actually sold any. And I don't know that I plan to start. Mostly I make leather work for friends and so forth. What do I think of the new push for gun control laws in Canada? I have a number of videos where I express my thoughts on that, and they are pretty negative. What is going on with the preacher that was arrested for holding services during COVID? His legal troubles have come to a middle. He keeps getting himself in trouble, and he keeps getting... some of the decisions against him have been ones I consider legally sound, some of them less so. Somebody says, have I had to represent a sovereign citizen? I have been fired by sovereign citizens as a lawyer, and that is always a happy day. So I see somebody saying, gonna do brutality again. Yes, I probably won't be able to do desert brutality this year, but I will be planning on doing more brutality events. Somebody
good.
asking about Appleseed events. Canada's got Maple Seed, which is usually done with 22s and is pretty good. So if they're anything like the Maple Seed stuff, I recommend those. And I see you're back from the washroom. So
Yes, thank you. I appreciate it. All right, let's keep going. I just couldn't wait. I saw it's like 2 more minutes, but I'm like, it's too long.
Do they work for defense?
Thank you, Your Honor.
And we'll indicate that time is being waived, and so our new last day, September 1st. With regards to the special action filing, if the Court of Appeals issues a stay and this court becomes aware of it, we will issue a minute entry. If either counsel becomes aware of the stay, simply let our division know and we will handle it accordingly. But Mr. Ruff, until the Court of Appeals issues such a stay, your matter is moving forward towards trial. Mr. DeBrigida will be representing you at this point. And so I would encourage you to participate in preparation with Mr. DeBrigida so that you're prepared to go to trial on August 2nd. You do need to appear for every hearing. If you fail to appear for a hearing, a warrant can issue. Then if there's been a bond posted, it can be forfeited. And hearing, including trial, can be held in your absence. With that, we will stand in recess in the matter. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, and I don't have a sword within reach, but I do have my Applegate Fairburn knife.
Oh, he says subject matter jurisdiction forfeited. I don't... Where did that happen? Where is this gotcha?
I have no idea. This is probably just he thinks there's a gotcha through Freeman on the Land.
Sure. I know, but I wanted to see him actually say he got his gotcha.
I don't think he explains it at all.
Mm-hmm. Oh, and Mr. Big sent me there's a third one. Jeez. No wonder he can't... Okay, yeah, there's apparently a third one. I don't know. How long is this stupid thing? Oh, it's 14 minutes. You want to stick around for another little bit?
Sure, we can do that. Somebody says, I like how Runkle's never far from a weapon. Yeah, there's usually several around.
Yes. Yes.
Because, hey, useful.
Mm-hmm. Yes. Yeah, subject matter... that moved. Subject matter jurisdiction is never waived, yes. But in his thing, he says subject matter jurisdiction was forfeited. I think he means the court is apparently lost it, but he doesn't show where that happened. So,
Also, some of the police have been saying that these are weapons.
Mm-hmm.
I've got a whole video on how that's dumb.
Somebody saying you're a weapon.
It's just a little. That's generous.
Oh, I was just seeing what somebody ever said here. All right, let's see. He gets their stupid little. Oh, stop sharing. Oh, hold on. That's why this is not working. Okay, there we go. Hold on. I gotta.
Oh, somebody also sent me some epoxy molds that I've got to play with.
You got
Where I
epoxy bullets?
No, epoxy molds.
Oh, I thought you said molds. I'm like, bullets made of epoxy. I'm like, I don't know if those are gonna last.
No, they're just little molds for like the sort of crappy things that you might put on a self-defense keychain.
Oh, yeah, with the Kubotans. Yeah.
Yeah, they're really stupid, but somebody sent me molds for it, and so I guess I'll have to try making those and commenting on how dumb they are.
Wow.
So.
And hey, Zens, I understand, but you say some funny shit, and if everybody in here gets their tampons all soggy over it, so be it. You say some funny stuff, man. So I apologize.
Oh crap! I was supposed to.
Well, did you see the congressman down here in New York? He's running for governor, and he got attacked with the cat face self-defense item.
Really?
Yeah, you know what
Jeez.
I'm talking about.
Yeah, I know the items
Thing.
you're talking about. I'm
Yeah.
just surprised somebody actually. So, how minimal were those injuries?
Oh, nothing happened. He got stopped.
Okay. I was just like,
So-
that doesn't seem like it'd be super effective.
No, yeah. But yeah, you can. I think most of those self-defense tools are not really
Oh,
effective.
they're incredibly dumb in most cases.
Yeah.
I mean, I got something right here that would be more effective than most of them. It's a file.
Yes, that'll hurt.
It actually would quite a bit.
Heck, I could start swinging this around. Just stapler. I mean, I don't know if you've ever actually stapled yourself or stapled a finger before.
Yeah,
Holy cow!
it hurts,
Yeah.
but it's not going to stop anybody.
No, but I mean, it's pain compliance. But yes, I would not want to get hit with a file.
Yeah, I don't think you're going to get much pain compliance from a stapler.
No,
You might
but
get somebody sort of confused. Hey, what do you? Stop it! That's weird. Why are you doing that?
yeah, please don't. Yeah, here it is. Okay, yeah, if you guys have not seen it, here's the picture. I'll just share this with you guys so you can see it. This is the thing right there. You can see it's got a couple little points on it, and if you look down, that's what it is right there. It's the
Yeah,
looks
those
like a
things,
little kitty cat.
those
yeah.
things are really dumb. Do not buy
Yes.
one.
Yes, ladies, don't buy them. They're a joke, and depending on where you go, they might confiscate those from you. So,
Yeah, I have a video where I basically just call the people out who sell those things on like TikTok and so forth as grifters.
Oh, wait, are you in TikTok or you said in your YouTube?
I did it on my YouTube and was mocking the grifters.
Oh, Paul Groats, God made men equal swing line. God made men equal. Okay, and somebody asked us earlier, you do have a right to represent yourself, but you have to be competent. It's not just anybody can do it. For example, somebody who's in like Forrest Gump would not be able to represent himself. Like, you have to have a certain level of competence. We don't just let anybody who's drooling and stepping over themselves, if they say they want to do it, we don't just let them do it. So it's not an absolute right. It's somewhat qualified. There were a couple people going back and forth on that, so I thought I'd clarify. But that was your little collection of tools?
Well, this is the little epoxy mold to make...
Oh, There you go.
Yeah, they're all stupid, and
Yeah.
I would not want to carry any of them. But
Yeah.
I may have to try just making them out of epoxy, and yeah.
You got to be like that Shop Time channel where the guy makes the epoxy molds out of other stuff. Like he'll make things using like shaving, like he'll use the epoxy, but he'll use like different things to dye it, different colors, and all kinds of stuff like that. Would the cat thing be considered a brass knuckle under some state laws? It can be. Those things you have to be careful about because it's clear those are meant to be a weapon.
Yeah,
So,
in Canada, they wouldn't be considered brass knuckles unless they're made out of metal, but you can still run into a lot of trouble for carrying them, even
Yeah.
if they're not considered a banned weapon. You'd still run into potential trouble just for,
yeah.
other issues on that.
Yeah, and I should clarify, they wouldn't necessarily consider them exactly just like brass knuckles, but they would be considered a weapon because it's clear they have no other use. So that's why you get plexiglass knuckles instead.
People make them, and
Yes.
people get charged for carrying them.
Yes, they do. Miners Zircon for $2. Thank you again for your super chat. A lot of questions for you tonight from him, Runkle. If you could move, what state would you move to if you could?
That's tough. I'd need to look up gun laws for one, and just climate and so forth. Because I don't like too warm.
Throw a state out there. I can give you a pretty good idea.
Virginia actually seemed pretty nice, although I've heard that their gun laws have gotten worse.
Well,
lately.
the problem is they can be very blue very quickly, so I'd stay away from there.
So I'd have to do some research.
No, West Virginia would be very good.
Yeah, and it seemed quite pleasant as well. So
yeah. 420 Shrek. What sovereign citizenship? It sounds like a bunch of BS. Pretty much. That's a whole nother.
It's like bullshit, but faster.
Yes. Yeah. You just sped run the entire argument of sovereign citizenry. It is bullshit. But Jasmine, I do not have enough time to take you on a carpet ride to explain it to you tonight. That would be a whole separate show. So hold on here. What'd somebody just say? Will I be? Oh, hey, Farron, how you doing?
Farron's in the chat. Yes.
Yes.
Hey, Farron.
Yeah. What was she? Will you be? Oh no, these are not like those types of keychains. I know what you're talking about. The Kubotans that that are ribbed and have textures on them for pleasure. No, this is not going to damage you that way. You'll be fine to look at them. Oh, what do you think about pepper spray? I mean, if that's all you got, that's what you got. But
I mean, it's better than a lot of these self-defense products there.
It's better than harsh language, but it's
better than a lot of stuff on the market.
Yeah. And be careful, depending on where you're at, that might be illegal. I think it's not legal in Canada, is it?
It's legal if you have bear spray or dog spray. Those are legal to possess, although depending on circumstances, they may not be legal to carry, depending on why you're carrying them.
Okay.
And but people spray, including spray that is marketed as for people and dogs, is illegal.
Ah.
Yeah. That said, something that is entertainingly legal, and which I purchased a while ago, is this.
What is that?
Just a little container of pure capsaicin.
Ah. You can just throw that at somebody and walk away.
I really recommend not doing that. But yeah, it's legal. I am not going to use that for cooking because ordered it from China, so who knows what the
capsaicin and fentanyl.
Well, hopefully they didn't send me any fentanyl. I haven't actually tried it, but I don't know. Like they say, it's food grade. Who knows how food grade it is?
Yeah, I don't know. I'd be worried about cooking with that if I put too much on something.
Well, I would imagine that it would be a great way to make something that you just can't eat.
Yes. Yes. Yeah, that would be an interesting way to defend yourself.
And I see Rob.
Yeah,
from
Rob. Yeah.
Yep, you did hear me talking about epoxy molds and resin work. I got this thing from somebody. So, yeah.
Yes. All right. Well, we're gonna, hey Rob, if you want to stop by, it's in the Twitter DM, but I'll send it to you if you're interested. But anyways, we're gonna start this one up and get it going. Let's hear what the final saga is at this point.
Sounds good.
Oh, we're in a different court now. More problems for this guy, but a different court now. Imagine that.
Who could imagine that this guy might be the kind of person who would have legal difficulties in more than one courtroom?
Yeah, and
courthouse.
Yeah, that's actually a nice looking courthouse. Nice looking courthouse.
You're gonna have to actually show it to us, though.
Yeah. Oh, God damn it! Thanks. Just doing so good.
Oh, and somebody was asking about do we get Runkle to do karaoke? I've only sung on a stream once, and that was on Uncivils. And so we'll have to go through all of his back catalog to see that.
No, that is a handkerchief. It's just folded up. All right.
0054491.
Wow, this is loud.
Christopher Ruff. Mr. Ruff, first of all, I would advise you, if you are recording, to please not. If you're not, then we're going to go ahead and have a hearing on whether you have the opportunity to record at your pre-trial conference on Wednesday. And I have received notice that you're requesting to use a smartphone to record your pre-trial conference. Is that correct?
I mean, I have a personal one.
Well, it's a smartphone, correct? Okay, I know your personal audio recording device, only a device that only records audio, has no other function. Okay, but that was not what your request was from, let me see. Because your request specifically asked if you could use a smartphone. Right? So now you're changing it to just using a audio only. Am I understanding that correctly?
For the record, I am allowed to use a smartphone per 122.1. The definitions of a personal audio recording device are covered in the cell phone. It can be used as a function only to record and not do anything else. It also provides a provision in the rules for the court to make sure that I'm only using an audio recording function on the cell phone. Make sure that I'm compliant with the rules.
I am perfectly aware of the rules, but I need you to tell me what the rules are. I have questions about what your intent is. Okay, and we can go back and forth. I know you know the rules, I know the rules, so we're going to follow the rules. Okay?
Yes, the brilliant rules.
A records request, and that request was made. Yeah, let me see.
I raised it up for you guys.
So I have the dates correctly.
Yeah, I know this audio sucks because he did it on his own. He didn't get the court audio.
All right, you, and I would also note, if either of you are recording, I would direct that you are not allowed to record in the courtroom.
Imagine that he's
Okay,
breaking the
so
rules.
on June 1st, you sent in a records request across the street to the records department over across the street, who forwarded over to us, where you had indicated, you indicated that you wanted to audio record, etc. And then at the end of that, you say, my question is, can I use my smartphone to record my court appearance after giving the judge notice? If not, I would like the statute that restricts my recording. So that was your question, asking for a smartphone. So when you were requesting whether you can use a smartphone is different under the definition of an audio recording. If you look at the specific rule, it says that a personal audio recorder is a device used to record audio only. So it only records audio. If you look at the definition of a recording device, it talks about an electronic or mechanical apparatus related to equipment used to capture or store sound images or those, or from which a person can retrieve or broadcast sound or images. A camera, a smartphone, and an audio recorder are examples of recording devices. So if your intent is to just use an audio recorder only, not a smartphone, not a device that has a function other than simply recording audio, that requires us to give the state notice because they have an opportunity to object if they choose to. Any witnesses or victims or...
Oh my god, this judge is making me want to jump off a bridge.
I mean, she's going through things really carefully.
I know, but oh my
And it's
gosh.
just because this is a self-rep and a particularly crazy self-rep, she's just laying it all out there.
I know, but I'm just like, oh my god, let's just get to it.
I mean, this guy's not actually as nuts, like as ragingly nuts as most of them.
Well,
Because he's able to,
he just conceals it well and holds
yeah,
it
that's
together.
the thing. He's able to keep it under his hat for a bit.
So
anyone involved in the case from the state side has a right to object. And if that happens, then they have a right to make that statement. And the court has to hold a hearing and allow that opportunity. So that's the purpose of today's hearing, is to determine if and under what conditions you would be allowed to record and what type of device you would be allowed to use. So if you're telling the court that you are intending to only use an audio device, that is a different situation than using a smartphone or some other device that does other functions. So I think that's where we need to first start with our inquiry. Because that will determine where we go. So do you have just a device with just audio only, not a smartphone?
The question with this, it's more of an understanding of how the rules are written, because I'm not hearing in Tempe courts, also in Mesa, Maricopa County, and Gilbert courts, and this is the only one that's trying to find this.
Okay, well, I can't tell you what another court does or what they not do. I'm looking at the rule and I'm reading the rule.
That's not how it is.
Okay, well, let me just,
Written specifically. My cell phone is a personal audio recording. But you're right, it's moot. I do have a personal audio recording.
Okay.
Anything else, but I come to court, I'm just gonna notify you.
just let me tell you that you also have a remedy if the court denies it. You always have a right to appeal it versus a special action. So you have a remedy if I prevent you from recording or using a device. So that's your right. I don't know what Mesa does. I don't know what Chandler does. I don't know what Gilbert does. I can tell you my interpretation of the statute, and it specifically gives definitions of what a personal audio recorder is and what a recording device is, and it tells the rules for each of those items. It also specifies that it's up to the judge to determine whether or not, after making specific on-the-record findings, there is a likelihood of harm arising from one or more of the following factors, and the harm outweighs the benefit of coverage to the public. So that is the purpose of a hearing. Now you have demonstrated on 2 separate occasions in this court where you have vagrantly violated the court's instructions.
Yes, it's like that's a reoccurring theme here. Oh,
It has been
jeez.
brought to the court's attention that you have gone out to the front counter, you have taken pictures of staff indicating to them that you were posting their images online. You have made statements in the courtroom.
Yeah, whatever beefs you may have with the judge or a prosecutor, if you drag court staff into it, that's not gonna go well for you.
Yeah, and all you're going to do at that point is at that, like, the judge might be like, okay, well, you're being a jerk to me, okay, but once you start being a jerk to the court staff, they are gonna go off, and now it's on. Now it's a problem.
Yeah.
So
yeah, Parallax, thanks for stopping by. Have a good one.
That you were going to post things online, and the court's concerned about that because I, as a judge, have the responsibility to uphold the dignity of what goes in this courtroom, to protect the privacy of anyone in this courtroom. And I will note that a pretrial conference, it is just not your particular setting. There are other people in the courtroom. There are potential victims in the courtroom. There are other defendants in the courtroom that would violate their privacy.
And you totally propose for
Well, you have a remedy, as I explained. So I am going to make a finding that if you are using an audio recording device only, it cannot be a smartphone, it cannot be a device that has any other function. You will be allowed to use it only when your case is called, and you need to turn it off as soon as your case has been addressed by the judge. That's fine, sir. As I explained, you have, sir. No, they cannot.
Yes, they can.
They have to go through the same process you do, sir.
Nuh-uh.
Okay, sir, we can argue.
Nuh-uh.
We can argue about this. It's not going to get us anywhere. So you have a remedy. You can certainly exercise that remedy. That's my finding. I am limiting that to that. And I'm also noting that if it comes to the court's attention that you are broadcasting any of the things in this courtroom, that is potential for contempt of court.
Whoopsie doodle.
yep.
I mean, I'm not, guys, you've heard me say it before, I'm not big on snitching, But I'm just saying, this would be a damn shame if this got sent to the court somehow.
It would be a real shame.
For the record, I am a reporter. Anything I do recording is going to be posted to the internet.
Okay,
For my record.
okay. Well, with that said, I am going to deny your request to record, period.
You can't do that.
I can, sir, and I am denying it. And for the record, I am denying it under Rule 122, subsection, excuse me, sir, but I would appreciate not being interrupted. I am denying under subsection D of 122 and under subsection G, 1G, under the denial of coverage, I am denying you the ability to record in any fashion based on your prior conduct and based on your statements.
What are you gonna do if I pay $17 for the audio that you just recorded right now?
You can certainly do that if you want, sir.
So it's a power trip right now. You're using your authority and accepting the judicial.
All right, sir. This matter has been concluded.
No, that part where she ignored you was a power trip.
Okay, and you have a remedy. You have a remedy. Court will be in recess.
You have a remedy means take it to the Court of Appeal. I don't want to hear your bullshit. And chat, is it just me that can't hear him?
Fuck, did it. God damn it. Fuck.
You are really nailing the technology today, man.
Yes, I am. Thank you.
Elaine, turn your mic on.
Fuck you fucking people. So, Metal, yeah, it's a public trial and everything's public. Why can't the public transparency? You can. You have to follow the court's rules, though, about I'm bringing in a recording device. Here's what it's going to be. And you notify everybody ahead of time, and you can go ahead and do it. That rule he was so big on citing in the previous video, he didn't follow here. So, you do have rights and you can do stuff, but you have to follow procedure and you have to follow the rules. He just didn't in the situation.
Yeah, and whenever you're relying on a rule to get the court to do something they don't want to do, make damn sure that you have followed every single step, because if they can find any single wrinkle on that, they will, if it's something they don't want to do, they'll be like, oh, you didn't follow step, 8 of the 12-step process, so tough shit.
Yes.
So, yeah.
Okay. Yes. Super chat for Lawn Lumber. Thank you very much. I appreciate your support for $9.99. Sean, turn on your mic. Thank you.
That's not what he said.
Well, turn your fucking mic on. Thank you. Thank you. So, yeah, if you want to come in here and cite the rules, you better have them down to a T.
Yeah.
Okay, yes. Stephen, you asked about hybrid representation. So if you have an attorney, that attorney represents you. And if you want to file like a motion for discovery or a motion to suppress, and you have an attorney and you retain them, or they've been appointed, their job is to file that. They're representing you. What can't happen is you can't go ahead and then file a motion to suppress, or you can't file a motion for discovery as well. Only one person, there can only be one captain of the ship, basically. So either you're running your own ship or somebody's running it for you. You can't have both. So that's what hybrid representation is considered. And I've had cases where I've filed I've been doing stuff, and all of a sudden a court calls me and says, hey, are you still you haven't withdrawn. This guy filed a motion. Are you still on the case? And I say, yeah. And they will send me a copy of it. And then usually the prosecutor or the judge, one of them will say, this is hybrid. It should happen. So
Yeah.
I hope that makes sense. I may sim for Rob. Yeah, this last one wasn't as good as I thought it would be. This was a letdown. Direct D, man, you let us down. I want the fireworks. I want the real stuff.
Hey, now.
um, let me see here. Yeah, I think that's it for him. I don't know if he's got other stuff. No, looks like that's it for now. Oh, I love this one. Are these stupid cops bothering you? Two cops try to intimidate us but fail. Yeah, I'm sure you did such a good job with those. Oh. Let's see here. What else we got going on? Nuts. 94.8 subs. Is that you or... Well, you're over that. I assume that's Rob he's talking about. So... let's see here. I think that's what he's talking about. Oh, don't want to... Shoot. Oh, Uncle, I was going to say real quick. If you want to watch a good video, Mike Glover, he does what he calls the Eli drill. He tries to do the 40-yard shots this guy was taking.
Oh, yeah.
Yeah, I don't know if you've seen that. Yeah, it was it's pretty good.
That's actually not a bad idea. Just try to take that out at the rifle range, because that's not easy.
No, it's not, and he scored like, yeah. Although somebody said something. Well, yeah, and somebody said something. He is a competition shooter, and I was just thinking, I'm like, I hope
8 out of 10 under stress.
Yeah, and people running all over the place, and
yep.
At first I had heard he used like a Springfield Hellcat, and I'm like, oh, I hope that's not the case. The Fuds will never let that down.
What was the firearm?
I think he had a Glock of some sort.
That makes sense.
Yeah. I was hoping it was that. It wasn't something like a fucking Taurus.
Oh no, I think it would have been really funny if it was some like absolute meme gun.
Yeah, or he had like a Hellcat or a Springfield XD. That would have just been awful.
Or like a High Point.
Yeah. Oh God.
Like just like some real piece of trash.
If that was a High Point, I would immediately go and buy share. Like I would, because it's about an hour away from me. I would drive to their office with a bag full of money and like, look, can I become like a partial stockholder in all this?
Have you ever played a game? I'm just trying to remember the name of it now. Receiver.
No.
Receiver.
No, I'm not. What is
Receiver is the game with the best gun handling mechanics.
Is it Steam? Is it on Steam?
Yeah, it's on Steam. You can pick up Receiver 2, as well as Receiver 1. But Receiver 2, I think, has the High Point. And what do you call it?
For $20, that's not bad.
Yeah, and what do you call it? It is absolutely fantastic at what it does there.
You don't need VR for it, do you?
Nope. You
Okay.
can use VR.
Well, that's... Oh, cool. No, actually, how am I going to get this? This looks pretty cool.
Yeah, and it's different from most video games in the sense that like you don't have a reload button.
Mm-hmm.
You have a button for every element of the reload process. So if you want to, like when you want to drop the magazine, there's a button for that. When you want to, add add cartridges to the magazine, there's a button for that. When you want to flip the safety on or off, there's a button for that. So all of these things have separate controls. So you have to actually know the reloading process.
Of that firearm. That's
Yeah.
pretty cool. Oh,
And I mean, it can give you hints as to all of that. But interestingly, the
Sure.
high point is one of the guns in there, and they exaggerate its difficulties.
Okay.
So one of the plot elements of the game is basically that you're in this simulation, and there's a supernatural force kind of messing with you in various ways, and so it will degrade the quality of your guns. But the high point is especially shitty.
Oh, I thought you were going to tell me the high point's like the one it can't attack.
The high point is just jammerific. It'll stovepipe. It'll whatever you can. It'll just screw up.
Oh, it's not that bad.
No, but in the game, it's especially
Yeah.
bad.
Oh.
So it's
Oh, they were saying, this guy we were making fun of, he has almost 100,000 views. Okay, yeah. Rob with another super chat from Rob for
subscribers.
$4.99. Yeah, how the F does that guy still have a channel? I don't know. And how he's got 98,000 and I've got like 10. Where's the justice in this world?
Sorry, is that views or subscribers?
No, he's got 94.8 thousand subscribers.
Jesus.
94,800, yeah. He's almost a 95.
You got to step up your game, man.
Yeah, I know. I got to start acting like a dickhead in court. I mean, I do that enough, but I guess I'll start recording it. No, this looks pretty cool. It's downloaded now.
Yeah, no, it's a good game. I entirely approve of it, but you spend a lot of time getting killed because the game is also super unforgiving in terms of you don't have a hit point thing. It's basically sometimes you can survive getting shot once, maybe. Yeah, I think getting hit is something like 90% likely to be lethal. So yeah. So yeah, when you step out, you get caught by a turret. It's like, and you're done.
Oh, that doesn't sound fun.
You got to be real careful, and there's plenty of moments where if you have fucked up loading and you have not lined that up, then you're gonna just get killed.
Oh, geez. Okay, yeah, that's a bit much.
Oh, it's I enjoy it, but it's
challenging. I understand. Yeah, no, that's gonna make it tough.
Well, I'm sorry to hear that that this guy has outpaced lots of people that I know in terms of channel.
Yeah, jeez.
That's disappointing.
Yeah, well, I mean, I guess that shows you there's 94,000 idiots out there. So,
actually, when I did Extra Life last year, and I'm going to do it again. One of the games I played was Receiver. Although I played it when I was a little too tired because I was late in the game, and I was just like, I have no patience for this now.
Yeah. Oh, somebody said, I thought Canadians weren't allowed to use the F word.
I've got a special dispensation from the Queen.
How long has this guy's channel been up? His channel has been up since September of 2017. So, yeah. Well, guys, I think that's it for tonight. Wow, it's almost 3 hours. So, yeah, there's nothing else from this guy to watch. The rest of it looks like a bunch of cringe, and I don't want to necessarily see him yell at cops because I see that enough in body cam video I've got to watch this weekend. So,
Oh, isn't it wonderful when your client yells at the cops and thinks he's, I'm helping, and you're like, no.
oh yeah, no, this is somebody said I got to step my game down. Yeah, maybe that's it. I'm running too esoteric of a game here. That's why nobody subscribes. All right. Well, anyways, Ian, thank you so much for stopping by.
Oh, thank
guys,
you. I just like hanging out with friends.
yeah, no, I appreciate it. Guys, he's at Runkle the Bailey. He does great stuff. Especially if you want to see from an attorney who practices and it's just across the border and how things go up there. I think it's very interesting. It's very neat to watch.
And
so,
was it? I'm probably going to spend the rest of the night playing receiver now.
oh,
Getting killed by turrets.
Yeah, once this loads up, I'll probably give that a shot.
Let me know what you think.
Yeah, I will.
You're going to spend a lot of time getting killed. I can guarantee that.
That's okay. I'm really interested to try this, especially the reloading. You've got me convinced.
Yeah, it has the most realistic weapon handling, and it's also entirely possible to kill yourself by playing too fast and loose with your guns.
Okay. Yeah, I was kind of torn. I was thinking about getting Ground Branch, but yeah, I'm definitely getting this instead. So,
no reason you can't get both.
Yeah, I don't know, like too many games at once because then I don't play them and then I bought them and they just sit there. So,
I don't want to tell you how many games I have that I haven't played.
Yeah, well, that's the thing. I go through every once in a while and I've cleaned out my Steam. So,
oh really? I just keep collecting them.
Well, I mean, well, my Steam's old, but I mean, I still have like old Half-Life mods that I had that I put on here that I haven't used. Did you ever play a game called Firearms Mod for Half-Life?
I did not.
Oh, okay. Well, before we go, it was like the precursor to Call of Duty and everything. You were given like the set amount of points, and you put the points into skills, but it was just faster reloading. You could be a medic. You'd have better medic skills. All the things you see nowadays. But then you could also just skip all of that and just use your points on guns. And the cool thing was there were all the classes of guns. There were pistols, there were submachine guns, rifles, battle rifles, machine guns, and then there were like grenades and explosives. So you could go through when you could carry if you spent all your points on guns, you could carry 6 different rifles, and you just went through and you just used them all up. It was pretty neat.
Nice.
It was really a lot of fun, but it was also kind of on shitty Half-Life 1, so it's definitely old school.
Awesome.
One more for Rob Super Sticker 9.99. Thank you, Rob. I appreciate it. But yeah, guys, that's it for tonight. Once again, yeah, give Ian a look, give him a subscribe, give him a shot. You'll definitely like it.
All right. Well, I will let you guys go and have a good night.
All right. Thanks, Ian. Take care.
Cheers.
And yeah, guys, that's it for me. Rittenhouse mode. Use a pointer to Put all your points of luck because that's what he needed. Oh, why are we done? Because it's been 3 hours. It's like 2:00, and I'm kind of tired. So, guys, I will see you next time. I probably keep doing these Saturday nights just if there's stuff going on or stuff to do, since there's nobody else here. Cannibalism just gross. Army Hammer again? I didn't know people were talking about him, but maybe we'll bring that up another time. So, guys, thanks again, and yeah, just remember until next time, just because you did it doesn't mean you're guilty.